For judgment item number 1, STRV 31 of 2011 and batch of matters.
So you held Chuni is not cattle feed.
Petitions are
And public. Who's for the petitioner?
Petition.
Let it come up. We'll see what happens. All right.
Obliged.
Weekly list, old matter item number 1.
Your Lordship, no steps have been taken. Your Lordship, similar order in STREB 119. This is 120.
All right. Same.
Old matter item number 2.
My lords, item number 2, learned senior counsel Mr. S.K. Naik is engaged specially for this matter. Is just undergone a cataract operation 3 days back. My lord, may kindly post it to any day after 15 days.
Item 2, 654 of 2008.
Yes. Civil Supplies Corporation. And also, there's a batch of 11 cases, of which only one has been listed. The one which has a counter is WPC number 646 of 2008. I am giving the entire list to the court master. My lord may call all of these matters so they can be disposed of at once.
Yes, that is.
One is listed, my lord. 10 more are also there.
Total 11 cases are there,
My lord.
All right. Along with those stated that the Naik, the senior counsel
My lord. SK Naik senior counsel.
appearing for the petitioners is unwell. List along with all those matters.
I'll give it. My lord is posting it to.
Third November,
Most obliged.
For the interim order to continue, my lord.
interim order.
And if they have filed a counter, they should serve a copy because state has filed a counter, but corporation has not filed a counter, my lord.
No, I have filed a counter. Because there are 11 matters, all are analogous. So counter is filed in 646 of 2008. Today 654 is listed.
Give a copy, sir. Kindly give.
I'll serve a copy.
All right.
My lord.
Weekly list, old matter item number 3.
Item 3, no instruction. My lord.
No instruction.
Weekly list item number 4.
None appears.
Weekly list item number 5.
Please, Your Lordship. Your Lordship, here we are challenging the order at Annexure 8 of Your Lordship brief, my lord. But before I begin, my lord, I must bring to Your Lordship notice that the noting is opposite party number 1 and 3. The opposite party number 1 is a contesting party, my lord. The AD is not yet back. But if Your Lordship wants, I can proceed with the matter. The noting of Your Lordship is OP number 1 and 3 is not back. And OP number 1 is the contesting party, my lord.
No, what's the matter about? But
My lord, my lord, here, my lord, may kindly have a glance at page 77 of Your Lordship brief, Annexure 8, my lord, which is an order dated 4th October 2010. My lord, we are agreed by this order of the Commission of Endowment. My lord, the petitioner is PK, it was erstwhile PKRIT, but now it is PKDA, Puri Konak Development Authority, my lord. I'm for the authority. Here, my lord, what had happened, the authority had bought a piece of land back in 1995. But before getting that land, my lord, we had already put up a advertisement saying that these are the parcel of land. This is what we are planning to do. There was no objection to that regard. We went ahead in 1995 and bought those land from a private person, my lord. Now, what has happened in 1999, a motto, my lord, a religious motto, goes and files a case. They filed 2 cases, my lord. One is a civil suit. Second is a section 25 before the endowment, my lord. Now, my lord, the suit was dismissed. Now, in the endowment, my lord, may kindly see, the commissioner has proceeded and has said that, no, it is not in the name of the private person, but in the name of the motto, because in the last settlement, it was recorded in the name of the motto. That's, my lord, the categorical finding, and that is the reason why they have given the order. My lord, may kindly have a glance at page 80.
no, but this matter, how come it's not served till now?
My lord, I'm also equally, lord, we have given
My lord,
notices.
in this matter, I am appearing for OP number 3 for Sri Jagannath Temple, my lord.
Yeah.
I have already filed my counter on 12/3/2014, my lord.
That's not on board, sir.
We have not.
I have already filed and copy already served. And since 12/3/2014,
No, it's not on, it's not even with us.
I can file another copy. Copy is with me, my lord.
You'll have to serve him also.
Yes,
I think he also
Can
doesn't
you
have a
serve
copy.
Another copy.
I will serve copy.
So opposite party number 1 has not yet been served. Fresh notice, thus in addition. To opposite party number 1 returnable. 9th November. You see, the counter affidavit of opposite party number 3 be served on concept of the petitioner and also be brought on record. Rejoined thereto if any be filed with the next date. Is there an interim order?
Yes, my lord.
Interim
There is
order.
an interim.
Interim order to continue.
Deeply obliged.
Weekly list item number 6.
And item 6, I am appealing for the petitioner. On last occasion, the Mr. S.K. Misra, as he was then he was appealing for the opposite party. Mr. Misra and myself both agreed for a settlement, but due to the allegation, it could not materialize. But kindly fix a date so that we can appeal before the consideration of the authority of the Honorable High Court, so the matter can be disposed of by way of settlement. We both have agreed for settlement.
I see.
Lord, I have no idea about the settlement.
And last time, Mr. Mrs. S.K. Misra was there. He lost his stage.
But I must inform your lordship that the opposite party number 2 is a widow, and she was appointed on a rehabilitation scheme in a regular post, and now she is only in her 40s. Now
She's getting 70B. She's getting 70.
Last order, it is not scanned.
Can you fix a date? We will settle it out. I'm interested for settlement. So that he can get some money and
the money is not important. She needs a job.
let us sit for a settlement. Any date, next week.
She's about 44, 45 years old.
No, is she not willing for a settlement?
I have no instructions with regard to the settlement, but she's only 44, 45, and she has a regular post. She was appointed under the rehabilitation scheme.
On the last occasion, his lordship, Mr. S.K. Misra was appearing, and he said that we would go for a settlement. So for that reason, I'm sorry. Because of
There's been a stay since 2012.
he's getting 17B. She's getting 17B. We're also giving her.
Where is she located?
My lord,
Where is she located?
I think she's at
Cuttack only. She's in Cuttack.
Yes, it's Cuttack, ma'am.
So she can easily appear in the mediation. Let us make an attempt.
Yes, ma'am.
You see, the parties will appear before the mediation center of the High Court. Yeah. On 17th August. The report of mediation will be placed before the court on the next date. List on 11th October.
Very good.
Interim order to continue. Copies of the order be sent to the coordinated mediation center. All right.
Weekly list item number 7.
May I please, your lordship? May I please, your lordship?
Yes, please.
My lord. Your lordship, my lord, I have filed the writ application, my lord, seeking a direction, my lord, to the opposite parties, particularly to the Kotak Development Authority, Kotak, my lord, to construct the sewage and drainage line in the east and south side of the plot bearing such and such, my lord, allotted to the Kotak Collectorate Employees Group Housing Cooperative Society in sector 10, your lordship. Lordship, may kindly see for a moment, but annexure 1. This is the allotment letter under group housing scheme, my lord, page 11. To the collected group housing society, your lordship. Your lordship, I will take your lordships to page 12, clause number 10. I may be permitted to read that, my lord, that you will not be permitted to construct open latrine not connected with charges for sewage line, septic tank. You have to pay the connection charges for sewage connection available. My lord, thereafter, my lord, what has happened? Though, my lord, the sewage line and drainage line has not been constructed toward the side of east and south of that plot, my lord, a representation was filed by the resident of that society, my lord, under Annexure 3, 4, and 5.
So
Before
there's
the,
no counter affidavit. Have you served the sewerage board or not?
but I have sought copy, my lord, before the to the storage board, your lordship.
Acha, they filed a counter.
But counter copy has not been sought upon.
They filed a counter quite some time ago, sir. Who's appearing for the
That is not
sewerage?
sought upon.
Who's appearing for the sewerage board? You should know the name of the council, sir.
Mr. Senior Advocate Bhuiya was appearing, but I do not know presently who is appearing.
They say the OWSSB is no more taking responsibility for operation and maintenance of CDA area.
Your lordship may kindly see for a moment Annexure 7, your lordship.
They have handed it over to PHEO since 21/1/2020.
That is not a, your lordship, for construction of this sewage and drainage, my lord, already sanction has been made by CD. Fund is not allotted to any of the parties, therefore it could not be constructed. Your lordship may kindly turn to page 41, Annexure 7.
Sir, you have not read the counter. We have the counter. We are reading the counter.
My lord,
So
I am
you are
sorry.
making submissions without reading the counter. We are telling you after reading the counter.
You oblige, my lord. Your lordship, let
They say
copy
they've
this.
handed it over to this PHEO. What is PHEO? Public Health Engineering Organization. You will have to make them a party now.
My lord, my lord.
In the counter affidavit of the OWSSB, it is stated that the operation and maintenance of sewerage and drainage system of CDA Cuttack has been transferred to the Public Health Engineering Organization, bracket PHEO, since 29th January 2020. In terms of a resolution of the Department of Housing and Urban Development dated 10th September 2019, and therefore OWSSB is not a necessary party. Paragraph. In view of the above submission, the Public Health Engineering Organization through its secretary is implemented as opposite party number 5 in the writ petition. The consolidated cost title shall be filed within a week, along with the complete address of opposite party number 5 by the petitioner. Full stop. Thereafter, fresh notice will issue to opposite party to the newly added opposite party number 5, returnable on 11th October.
Weekly list item number 8.
Oblige.
None appears to assist knowledge.
Weekly list item number 9.
I'm appealing for Ukti 5 and 6.
None appears to assist knowledge.
Weekly list item number
Item number 9. May please, my lord. On behalf of Mr. SBJana, my lord, the impugned order is at Annexure 3. The petitioner was working as a DLR watchman with effect from 12/3/94 till 8/5/95. Then, my lord, he was retrenched from his service by way of refusal, my lord. Then he had approached the labor court, and under Annexure 1, the labor court has directed to reinstate the workman in his service. And then the management has challenging the said order under Annexure has in WPC number 6082 of 2009 has had approached this honorable court, and this honorable court has set aside the ex parte order and directing to restore the said dispute subject to payment of rupees 10,000 by the opposite party to the petitioner and also directed to dispose of the said case as expeditiously as possible. Well, under Annexure 3, the Labour Court has
Directed reinstatement.
yes, my lord. Under Annexure 3, the Labour Court has directed that Section 25 triple F has been
So they have directed reinstatement of the workman.
under Annexure 1, my lord.
There is no stay granted by this High Court of that award,
My lord,
of the award dated 12/8/2011,
yes, ma'am.
which you have challenged in this writ petition.
Yes, ma'am.
There is no stay
No.
granted by this court.
No, ma'am.
So have you taken the person back?
No, my lord. The management has not yet reinstated the.
How come? For last 10
the order,
years,
in the order, it has not been mentioned to reinstate the petitioner in his service, my lord.
petitioner or you were the petitioner, I thought?
Yes, my lord.
Ah,
In my lord, in the order, it has not been mentioned to reinstate the petitioner. I am challenging that award, my lord.
you can stay. Even notice has not gone in this petition so far, sir.
My lord,
The last 8 years,
yes,
it is just stuck in the stage of defects. Why did you not remove? You
My
did
lord,
not remove the
defect has-
defects.
my lord, defects.
Despite 8 years, you have not removed defects, which is why the matter never came up. On its own, it is listed today. You're not interested in the matter, I think.
My lord,
Not really. Because the workman is getting only 25,000. You're not even sure he's got the 25,000, correct?
No, my lord, he has not yet got.
Have you taken any steps for that?
My lord,
You are not aware.
no.
Matter has come up in the list. So quickly this morning, you've just brought the brief and now you're standing here and reading it.
My lord,
Yes, that is what has happened. No instructions. They're not getting back to the client.
my
Nothing.
lord, my grant 1 week time, my
No,
lord.
everything. So we can go on. We are sitting here only to grant adjournments.
Sorry, my lord, my lord.
No, we are also very sorry. See, nothing has happened in the last 8 years. When it comes up, first thing, ask for adjournment. Don't get ready with the matter. Don't talk to the client. Don't remove the defect. For 8 years, not remove the defect, sir. That's why not even notice is gone in the petition.
My lord, last chance may be given, my lord.
No, for whom? That's the point.
My lord,
If you give you last chance, again you will go back to sleep.
no, my lord, my
Yes,
lord.
yes. That's the problem, sir. The minute we give you last chance, you'll go back to sleep.
No, my lord, last.
I don't understand. For the last 10 years, defects have not been removed. On its own, the matter is listed today. And the petitioner wants more time. The court is not prepared to grant such indulgence, considering that the matter has already been pending for 10 years. The petition is dismissed for non-possible.
Weekly list item number 10.
Lords, item 10, my lords, I am appearing. My lords, here the ombudsman order is under challenge, wherein the ombudsman has reversed and quashed the order of the GRF, dismissing the complaint petition. GRF has dismissed the complaint petition and ombudsman has quashed it. My lords, the issue is that the complainant has raised two issues mainly regarding the billing imperfections made during the month of January 2011 and February as well as March 2011. In respect of January 2011, my lords, the complainant raised the issue that the billing has been made on the basis of two separate connections. My lords, I may appraise your lordship about the background of the case, since it is very technical in nature. My lords, the complainant availed the power supply since the year 2005 and subsequently by executing the agreements in subsequent years, the contract demand was raised in the year 2008 to 8500 kVA at 33 kV power supply line in 2008. Then further it has been extended in the year 2010, my lords, by further executing an agreement by enhancing the power load from 8500 to 15,000 kVA at 220 kV power supply line, my lords. My lords, the issue arose in the year January 2011, since in December itself only the agreement was executed and the the contract demand was enhanced. So, but my lords, even after the demand was raised and the power supply was changed from 33 kV to 220 kV, but still the petitioner requested the licensee to retain the 33 kV for a period from 1st January 2011 to 28/1/2011, beside retaining the subsequent 220 kV line. So accordingly, my lords, the bill for the January month has been raised on two separate connections for 33 kV as well as for 220 kV. And it has been rightly also held by the GRF in its order. The complainant mainly raised the contention that since I have already raised to 15,000 kVA, so my contract demand shall not exceed more than 15,000. But here in this case, two separate connections were kept until the end of January 2011. So the reason stated by the Ombudsman while quashing the order of the GRF, that it was our duty to have disconnected the earlier 33 kV when he has already enhanced to the 220 kV, but that cannot be the situation as per section 43 of the Electricity Act, because duty lies upon the licensee not to disconnect until and unless the request has been made by the complainant to disconnect the supply. So he was availing two separate connections. Accordingly, the bill was raised for January 2011. This is the first issue, my lords. Well, so far as the second issue is concerned, as far as the bill for February and March 2011 is concerned, my lords, another issue arose, which the licensee was also not aware of the fact that the company in the month of February had installed a captive power plant in its premises for exporting the units to the OPTCL for since February 2011. So when there was no agreement itself to that regard for any export for exporting the supply in addition to importing, because initially and basically the meter was installed in the premise of the company for importing the units, but he also installed the CPP, that is a captive power plant, for exporting also in addition to importing the units. So when the bills were raised in the months of February and March on the basis of the SEMS meter, that is SEMS secure meter, that has been installed in the premise of the company, that we have clearly also mentioned in our reply at page 22, annexure 2, my lords. Everything clearly we have stated in para 5, my lords, para 4 as well as para 5, page 24, that the billing has been made on the basis of the apex meter installed in the grid station at Duburi. What the complainant alleged is that the export unit should have been deducted from the bill, as they are not liable to pay for the export unit but only for the import unit. But our contention was that since there was no agreement or any also regarding any written instruction regarding the export for exporting the unit, so that question does not arise at all. So accordingly, the bills was raised on the basis of the apex meter that was installed in the grid station, and it was raised correctly, and it has been rightly held by the GRF also. Because that GRF finding, my lords, it is at page 41 of the petition, my lords. It has been clearly stated, my lords, if my lords may kindly refer to. Admittedly, neither there was any agreement between the parties for affording due credit to export of power to OPTCL through proper metering, nor there was any written instrument being signed by the parties for making necessary arrangement for the evacuation of the surplus power from the CPB, that is captive power plant, of the complainant to OPTCL grid. Therefore, the contention of the complainant that even though the opposite party was informed about the arrangement of export of surplus power to OPTCL, but not restored suitable metering for maintaining a regular inventory of export vis-a-vis import of energy is not acceptable before us. Further, on the basis of said contention, we can't regard the meter that was put in place originally as defective as claimed by the complainant. Had there been an express agreement or arrangement in writing to govern the aforestated affairs of export vis-a-vis import of electrical energy, we would have viewed the matter otherwise. Things would have been different, and it would have been a case for the complainant if there had been an agreement to that effect. And it has been further also held by GRF that we view the energy billing done in the petitioner's account by taking grid meter record into account as more logical and concrete. During January 2011, the petitioner has availed two supplies at 33 kV and 220 kV under separate agreement. Hence, as per our considered view, the energy bills claimed for the month of January 2011 by taking record of 2 meters separately into account is as per agreement and regulation. Now, my lords, if I may come, I may refer your lordship to the ombudsman order, my lords, on the same cause and all the same grounds he preferred appeal before the ombudsman, my lords. And the ombudsman
is pointing out that you should have disconnected one power supply when you gave the another power supply, right?
My lords.
You could not have had both. This was not under his control.
My lords.
You allowed him to avail 33 kV. The day the 33 kV started, you should have taken out, disconnected the 220 kVA. Now you give him two bills. Naturally, he goes to the GRF saying, what is this?
My lords, 220 kV was subsequently, it was enhanced, but that 33 kV was retained until 28/1/2011.
So how is he responsible?
My lords, he himself admittedly requested the my lords licensee that has been admittedly also my lords referred. My lords, at para 4 of the reply at page 23, my lords, if may kindly refer to,
yes.
As per the letter of the OPTCL dated 6/1 at the middle portion of the para 4, I am reading, my lords, as per letter of OPTCL dated 6/1/2011, the petitioner company has to disconnect 33 kV connectivity with NESCO within 15 days after availing supply at 220 kV from the grid substation Duburi. The petitioner has also made a request, my lords. The petitioner has also made a request to avail power supply in 33 kV for 15 days besides 220 kV supply, vide its letter dated 24/12/2010. So, my lords, upon the request of the complainant itself, it was not disconnected, and we also are duty bound to supply the system as per the provisions of the Electricity Act, my lords. And subsequently, it was disconnected on 29/1/2011, my lords. Finally, 33 kV supply system was disconnected on 29/1/2011. So, from 15/1/2001, the petitioner availed power supply to his premises in two supply systems as per his own request, my lords. And according to prevailing RST order, the petitioner company was billed in January 2011 on the basis of meter reading separately for 33 kV and 220 kV supply system. So the petitioner company availed power supply for 33 kV for few loads and in 220 kV supply systems for other installations. The above fact was duly communicated to the petitioner vide letter dated so-and-so 14/3/2011. So bill of January 2011 was prepared considering 8500 kVA on 33 kV supply system from 1/1/2010 to 28/1/2011, and considering 15,000 kVA on
Going on
220
reading from something or the other. You're not answering the main
for
point,
2 periods,
sir.
my lords. For 2 periods, he was
Going on endlessly. You're reading from something or the other.
My lords.
Come to page 62. You have to deal with the point that the ombudsman is raising.
Yes, my lords.
Come to the third paragraph.
My lords, the respondent issued bill for the month of January 2011.
No, page 62.
Sorry, my lords. My lords, para 4, my lords.
3. Further, the respondent is allowed.
Further, the respondent has allowed the petitioner to avail 33 kV supply in addition to 220 kVA supply for a period of 15 days, which was disconnected on 29/1/2011 to facilitate stabilization of new 220 kV system without looking into the instrumentality of the agreement. The 33 kV power supply should have been disconnected on the same day when 220 kV power supply was made effective. Or else, if it was not done considering the technical aspect of the new system, the respondent should have thought commercially to modify the agreement basing on the deviation so made. Although the opposite party's argument of billing on individual agreement basis is correct as per the tariff, but they have wrongly operated it not by disconnecting the 33 kV supply, which created irregularities in the views of the agreement.
That's the whole problem. Even para 4,
my lords,
did not have the provision to record both the import and export energy separately. And it was adding them together.
My lord, since
this
there
was a
are
problem.
My lord, since there are 2 separate connections, there is no problem in my lords raising the bills, computing the energy bills from 2 separate power supply, my lords.
Right.
My lord, section 43 also, my lords, gives the responsibility upon the
It's all right.
licensee, my lords.
Taken is a possible view to be taken.
Another only one point, my lords, I may apprise. Regarding the installation of the new meter as directed by the ombudsman, that is a completely new issue raised by the ombudsman because there was no issue canvassed by the complainant regarding defective meter. So, my lords, regulation 97 does not come into play in this case.
Page 63, the only relief granted is in page 63.
63 also directed that to recast the energy bills on the basis of
not to install a new meter. That's not what.
Regulation 97 has been stated.
There is no direction that he should be given a new meter. Where do you get that?
My lords, as per regulation 97 of the OES supply of 2004, recast of the energy bills on the basis of average meter reading for the consecutive 3 billing periods of the new meter, my lords, replaced. So they have casted a duty upon the licensee to install a new meter.
No.
My lords,
where do you get that? Recast the energy bills on the basis of the average meter reading for 3 consecutive billing periods of the new meter already replaced.
My lords,
you've already replaced, sir.
Subsequently, it has been replaced, my lords.
Whatever, you've already replaced. There's no direction for you to replace it now.
My lords.
You say the challenge the present petition by the executive engineer, Nesco, Jashpur Road, Jashpur, is to an order dated 20th October 2011, the Ombudsman, issuing the following directions to the petitioner. Take from page 63. By the above order, the Ombudsman reversed the order of the Grievance Redressal Forum, bracket GRF, dated 30th June 2011, against which the opposite party had filed an appeal before the Ombudsman. Consumer representation case number 37 of 2011 before the Ombudsman. Paragraph court has heard the counsel of the parties. One controversial issue was whether one issue that was dealt with by the Ombudsman was whether fresh bills had to be prepared for the months of January and February 2011. In light of a new meter having been installed to replace the old meter which did not have a provision for recording import and export energy separately. Full stop. This energy meter bracket SCMS was provided with the 220 kV system. Full stop. Since this meter is defective, the bills for the period from February to June 2011 is prepared by NESCO with the data of Apex meter stationed at New Duburi Grid Station, where export recording was available. Stop. It was noted by the ombudsman as under, take from bottom of page 62. And top of page 63 paragraph. It is after the above analysis of the factual position regarding the replacement of an old meter with a new one, that the directions extracted above have been issued by the ombudsman. So the view taken by the ombudsman appears to be a plausible one. And in exercise of its jurisdiction under Article 226 of the Constitution, the court is not inclined to declare. The petition is accordingly dismissed. The interim order is vacated.
Wiki list item number 11. The dues under section 17B has not been paid. Although the industrial tribunal as well as the High Court in writ petition in writ appeal allowed the claim, and he was paid the dues partly, but so far as 17B is concerned, throughout the proceeding, my lord, it was not paid. And during pendency of this case, when notice has already been issued to the opposite party, the petitioner expired. And immediately the legal heirs have been substituted.
No,
I have filed an
understand.
application for substitution, my lord. And they have not filed any counter, nothing.
No, I don't understand. Where is the question for 17B applying here?
17B
during a writ petition here.
Subject to lordship's correction during pendency of the case before the High Court or the Supreme Court, my lord. 17B applies.
No. At whose instance, sir? This is the workman who has come, right?
Yes, madam.
What have you come against? You've come against the order of the tribunal.
No, I have not come, my lord. They have come. I approached the tribunal challenging the decision.
They have come in. Where is that petition?
That I have filed the order, my lord.
No. Where is the petition? That petition is over.
Yes, that's over. That was allowed in my favor. They challenged it before the Honorable Court in writ petition. That was also allowed. They again went on in writ appeal. That was also allowed. In the writ appeal.
Everything can't be allowed, sir. They must have failed the writ petition. That is why they went in appeal to the writ. You kept on saying allowed.
Oh, sorry, sir. That was in my favor. The judgment was made in my favor, Lord. And thereafter they went to writ appeal, and writ appeal, there is an observation that this application should have been outrightly thrown because 17B has not been complied.
No, but this you filed this like an execution petition. This writ petition can't be an execution petition for your 17B wages. You have to go either to the labor court or whatever. You have to go under 33C. You can't file a writ petition for this, sir. Where do you get this? You file a writ petition to recover 17B. There's no such provision. You are appearing for the management.
Yes.
What is your stand?
My stand is that it was dismissed. We have paid the money. A contempt was filed against us. The contempt is still pending. The contempt number is contempt number 541 of 2012. We have paid about 7 lakhs rupees.
It's pending before the single judge. Whom is it pending before? Or this
Contempt is pending before your lordship.
That's not regarding this 17B claim, Lord. That is pending because the direction of the Honorable Court to pay the due that has been allowed by the industrial tribunal, that was not paid. And when writ appeal was allowed also, they played part of it has been paid.
No, but one doesn't understand. For one portion of the court's order directing 17B, you don't file a contempt when they don't comply with. You choose to file a writ petition. And for the other portion, when they have directed something, for that you file a contempt. Why have you split up like this?
No, there was no order regarding 17B in the final judgment of this Honorable Court.
How can the 17B in the final judgment? I need to understand this, sir.
My lord,
17B is an interim relief.
My lord.
My lord,
they
how can they in the final order
lord,
ask for 17?
I agree, my lord, 100% agree, my lord. But here, since they did not pay the due, statutory due, therefore I filed an independent application here.
No. This is completely misconceived, sir. You should have filed a contempt when the matter was still pending. If a 17B order was not complied with, while the writ petition was pending, you should have filed a contempt.
There, my lord, in writ appeal, this Honorable Court observed that the application of the management should have been outrightly thrown out because of non-compliance of 17B. That is page, you may see for a moment, page 41. Paragraph 4. They say, learned counsel on behalf of the workman submits that employer cannot maintain the writ appeal at the award passed in favor of the workman was challenged before the court of WPC number so-and-so, learned single judge on the basis of so-and-so, has directed the employer to pay the wage payable to the workman by his order dated 28/3/2008 during pendency of the proceeding before the court. The order has not been complied by the appellant. Therefore, not only the workman, but also the family members have been put to penalty.
What's the date of this order? 3rd November 2011.
The writ appeal, my lord. The writ appeal was disposed of in 2011, 2010-2011. Page 40.
You have not filed any reply, nothing here for the last 10 years, sir.
No, this writ petition, we have not filed reply. We have filed the show
So
cause in the
you
contempt.
agree with everything he said in the writ petition. That's the conclusion that we have to draw. If you have not filed a reply for 10 years, which means you accept everything he said in the writ petition.
The question is that the writ petition is not maintainable.
Where have you said that?
An order
Where have you said
passed
that?
under, my lords, an order passed under Article 227 is a decree as per the Orissa High Court rules. If it is a decree, it is executable before this Honorable Court, not under Article 226.
I don't
A fresh writ petition is not maintainable. Because after the final adjudication in the writ appeal, we have paid the amount. 7 lakhs something has been paid to the widow. So cause of action doesn't subsist.
What happens to the 17B order that you were supposed to comply with?
That has been amalgamated in the final payment, my lords. Whatever payment this petitioner, Basan Mahapatra, was to get, he has received through his widow. He died in 2015, we paid to his widow. And that 17B order is an order under...
Where is a contempt petition? What's that number?
CONTC 541 of 2012.
No date has been given in that.
Your Lordship.
No date.
It's a list along with contempt case number
541 of 2012.
541 of 2012. On 11th October.
Weekly list item number 12.
May it please your lordship. Will someone VC now?
Yes.
Right. But here the impugn order is actually revisable. It's a proceeding arising out of OPLE Act, and the impugn order is under appeal to the original order, lords.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to challenge the impugned order by way of a revision petition under the OPLE Act. Disposes withdrawn with liberty spread.
Weekly list item 13.
Status quo operating in my favor, my lord. 26/3/2012, my lord, I'm still in possession, my lord.
All right. If such revision petition is filed not later than 5th September 2022, accompanied by an application condition of delay, if any, then and citing the pendency of the present petition as the reason for the delay, considered in accordance with law by the revisional authority. Provided the revision petition is filed within the time stipulated. Till such time, the revisional authority passes an interim order on an application to be filed by the petitioner for that relief. The status quo order passed by this court on
26/3/2012, my lord.
Will continue. 26/3/2012. Petition is disposed of the above terms.
Weekly list item number 13.
Your lordships, on behalf of Mr. Jana, the matter has become infructuous.
Infructuous disposed of.
Weekly list item number 14.
None appears to system number.
Weekly list item number 15.
Lordship, SK Samant is in accommodation, the lordship. Let the matter be taken.
Every day it can't be an accommodation, sir. Something you'll have to argue the matters.
Lordship, SK Samant went to perform his elder mother.
That was 2 days ago.
Yesterday, lordship.
I see. Mr. Samantra stated been some difficulty. When have you listed those other matters? Yesterday's matters were adjourned.
Yes.
When did we adjourn it to?
Next week, lordship.
We never say next week, sir. We always give a date. You don't note down, you don't bring the brief. So you're in a very happy position. When we were in the bar, we could not be so happy. No memory, no need to remember dates, no need to bring the paper book. Only one standard line to tell the court. Very happy, sir.
I will find out that date and I will intimate to Mr. Potops.
22nd November. All right.
Weekly list item 16.
This is a public interest litigation.
1 minute. You never bring paper books.
Yes, sir.
You have?
Yes.
All right. All right. Yes, yes.
My lord, this is a public interest litigation regarding the performance of different occasions of festival of the famous Dhanu Jatra in this town of Bargarh. My lord, here the state has the private opposite parties have managed to record their name in their personal names of the properties belonging to the state. And over these properties from years together since 1911, the performance of different activities of Dhanu Jatra, like the grazing of cows by Lord Krishna and the childhood memories of Lord Krishna are enacted or dramatized in this. This is an open air theatre which is organized in the name of Dhanu Jatra of Bargarh. There, the state's properties have been recorded in the name of the private opposite parties in their individual capacity. We are bringing this to your lordship's kind consideration that state, in spite of knowing that, has not taken any cogent step in getting those records corrected. And state has not filed any reply to my writ petition, which is before your lordship.
It hasn't filed since long. 4/3/2013.
State has not filed. State has not filed. Private opposite has filed. I have got the copy.
So the deputy collector, I don't know what you call him, deputy collector, collectorate Bargarh has filed.
It has been filed on behalf of opposite party number 1.
Well, that copy they have not served me. I have got the copies of the private opposite parties. If state has filed a counter, my lord, they have not served me copy. Only this counter affidavit of the Private opposite parties are with me. And my lord's interim order, your lordship will see dated 11/1/2012, your lordship had directed that the collector burger is directed to ensure smooth functioning of the Jatra.
No, but they admit that it is recorded in the private opposite.
Yes, my lord. That we are saying that how can it be recorded in private line? Because these are all government properties.
How do you know?
My lord, I have got the record of rights that it was in the initially name of the government.
No, but it has been changed subsequently.
My lord, government
MS record was prepared and published in 1970.
My lord, that the state should ensure that their properties are secured. Their properties are secured so that this function is not disturbed.
It is not disturbed. It apparently happened. It was not disturbed at all.
No, it is recorded in private.
This year is the 64th Dhanu Yatra Mahotsav. This is
My lord, that is by virtue of your lordship's
and it's
interim
already
order.
been celebrated from 17th to 27 January 2013.
Yes, my lord, that is by virtue of your lordship's interim order. Your lordship has protected that portion in the interim order. But what steps they have taken to get it corrected in the name of
they're saying it is only in the private parties. They say they have no power to correct it.
My lord, it is the state property.
They don't say that, sir.
My lord, let them file a counter so that I can serve a copy. I can.
What is your stand?
Well,
What is
you
your
are saying
stand?
paragraph 6.
Yes.
It is humbly submitted that Hamid settlement ROR was prepared in 1930. The classification of the land under Hamid settlement Khata number 33 of Mauja Ambapalli was mango orchard, and there was number of mango trees on the case land and note of possession of different persons as well as village community as mentioned in the remarks column. Dinabandhu Pujari had the right to collect fruits and used to collect the land revenue as intermediary before abolition of estates. At present, there is no tree on the case land. Then in paragraph 8, we have stated, as per the provisions of the Odisha Consolidation of Holdings and Prevention of Fragmentation of Land Act, final ROR of the village has been published on 14th.
So if somebody is aggrieved by this final ROR, they can move under the act.
Yes. Consolidation Act, there is provision.
All right. You can move under the act, sir. If that final ROR has been published in 14th November 2000, you can easily go under the act.
My lord, we are private, individual, public. There, that is the states look out to ensure safety.
They are not
their
interested, sir. They are saying opposite party has no scope to make any changes in the ROR.
Then your lordship may grant me leave that I will move the appropriate authority for correction of the record of rights.
Okay.
That leave, if your lordship grant, I can file a revision before the appropriate authority.
The stand of the opposite party number 1 is that although the land was used for the purpose of Dhanu Yatra for well over 6 decades now, 6 decades at the time of filing of the reply by the opposite party, that is 4th March 2013. The final record of rights published on 14 November 2000 under the OCH and PFL Act has been recorded in the name of the private opposite parties. Or to Radhesham Pujari onwards. No. In the name of Paragraph 5. The MS plot has been recorded in the name of itself. Correct. In the name of Radhesham Pujari, Sitaram Pujari, Janakiram Pujari, Ghanshyam Pujari, Tulsiram Pujari, Naveenasham Pujari, all sons of Neelamani Pujari. It is stated that the MS record was prepared and published in the year 1970. It is further stated in para 8 that opposite party number 1 has no scope to make any changes in the said ROR under the OCH and PFL Act. What's the position under the Act?
Section 36 provides for revision.
No, 36 against an order passed under section 9 and 12 and 18. If there is the direct
inspect the
change,
record. What will permit you to do is inspect the record if you want.
and under 37, I can file a revision. The Lordship may grant me that leave under that section.
Why should we grant if you already have that? You
No, I may here, my lord, once he is not an objector to the recording, his scope is limited. So unless your lordship grants that, I can challenge that in revision, because state's property, state is keeping silent. So 37, any person aggrieved can come up before the commissioner. Lordship may say under section, give me leave under section 37(1) of the OCH and
no, let's see 37(1). If you already have permission to do that, why should
no? Here, my lord, there is that scope is a limited power. 36 is the general rule of revision.
Revision is section 25, no?
37 is a limited jurisdiction.
Not the rules.
Six is the general provision of revision.
Six is revision. Agreed. Yeah, so he will. You are also an agreed person. Doesn't say unless you participated. Any person aggrieved can file under 36(1). But it has to be done within 90 days.
Yes, ma'am. That is the.
You came to the court itself only in 2012.
Yes, ma'am. My lord, after coming to know that it has been settled, we are before your lordship. After coming to know that the private opposite parties have taken over the government land.
There's no provision for consideration of delay, I suppose. Is there a provision?
Yes. Yes, madam. There are provisions. Section 5 applies, madam, of the Limitation Act.
Counsel for the Counsel, Mr. A.P. Bose, learned counsel opinion for the petitioner states that the petitioners will avail the remedy of filing a revision petition under section 36(1) of the OCH and PFL Act 1972 against the ROR published on 14 November 2000. It further stated that the said petition will be filed on or before 12 September 2022, along with an application for condonation of delay. On account of the pendency of the presentation. In the event such revision petition is filed, it will be considered in accordance with law by the revisional authority and disposed of within a period of 4 months thereafter, till such time the status quo order passed by this court on
not on 11/1/2012.
11/1/2013. 13. Shall continue. Petition is disposed.
Obliged.
Weekly list item number 17.
None appears.
Weekly list item 18.
17, 18, 19, and 20 could be.
Yeah, none appears. Up to 20.
Right. Weekly list item 21.
None appears.
I'm for the opposite party workman.
All right.
Weekly list item 22.
22, I am for the opposite party.
None appears.
Weekly list item 23.
23, my lord, no instructions.
No instructions.
My lord, I am for the opposite party bank, my lord.
loan account has already been settled under compromise, my lord. And
He anyway says no instructions.
weekly list item 24.
None appears this response.
Weekly list item 25.
Item 25, my lord. I mean, VC, my lord. The OEA case was allowed by the Tahsildar at Annexure 2 at page 17. And it was direct order was passed to send the case record to the sub-collector for favor of kind confirmation. But the Tahsildar is not sending the case record to the sub-collector for confirmation. Only this is the grievance. At page 7.
Endowment commission was required to make a party loss. There's a noting loss we can find earlier.
No reply filed, sir.
No step has been taken by counsel to petitioner.
Yeah, no stake taken. Correct. You did not implead the commissioner at all.
No, man.
This court had required you to file an application to implead. You've not done that.
Private DT, man.
Sorry?
Private DT, man.
So there is an order of this court requiring you to implead the commissioner.
Annexure 1.
21st August 2014, this court has passed an order in this petition directing you to implead the commissioner of endowments.
No, my lord. He has not made party.
Says despite a specific direction given to the petitioner on 21st August 2014 to implead the commissioner of endowments as a party for over 8 years now. For nearly 8 years now, no steps have been taken. It appears that the petitioner is not interested in pursuing the petition.
No instruction also.
Correct.
Weekly list item 26. 26, the impugned annexure 4 and 5, wherein the cancellation of upgradation of the post of junior stenographer to the senior stenographer has been cancelled and have been reverted. And thereafter this honorable court by order 28/9/2012 have protected in an identical matter from junior assistant to senior assistant. This honorable court has already allowed the writ application in respect of the very same organization. When the copy. Referring to Rule 6 of the 83 rules, Your Lordship.
In respect to the same opposite party number 3, Paradeep Development Authority, target PDA. A writ petition was filed against it by Sushant Mahapatra, who was also aggrieved by reduction of the petition, the scale of pay.
No, here probably the facts are different. Hello, as it appears from the order.
There was junior assistant to senior assistant, here junior stenographer to senior stenographer.
Here, my lord, the order which has been placed before my lord, there was question whether the salary of the petitioners who were working as senior assistants, whether that is permissible or not. Well, here in the instant case, there is upgradation of the post.
There also is upgradation. So say second paragraph.
My lord.
The grievance of the petitioner in this writ petition in nutshell is that the petitioner joined as junior assistant, continued till 2007, when the said post was found upgraded to the post of senior assistant.
Here it has not been upgraded. Here it has not been upgraded, and government has taken a decision as to why the post of junior assistant cannot be upgraded to the senior. assistant post. Your Lordship may kindly see the impugned
No, but the
order.
same organization. It's
No,
the same
posts are different
organization.
because once that post is upgraded and the base level post is abolished, that is why we have assigned the region at page 15.
That was the similar case there, Your Lordship. The proposal for upgradation was there from junior assistant, senior assistant in the case of Sushant Mahapatra, and thereafter they had cancelled and proposed for reversion and the lower reduction of scale of pay. This Honorable Court referring to Rule 6. The Rule 6 has also been quoted in that order, Your Lordship. In the second page, it is quoted, bottom, Your Lordship, Rule 6 of the Odisha Development Authority rules, which read as follows: appointing authority, supervision and control. The powers of appointment, promotion and punishment of officers and employees of the authority other than those on deputation shall vest in the vice chairman. And in the counter affidavit in Sushant Mahapat, they had also admitted that has been referred in the first page, Your Lordship. In the first page. A counter affidavit has been filed on behalf of the OP number 2 by the Secretary PDA, taking a stand that the Secretary PDA has stopped the salary in the upgrade post from September 2010 onwards due to non-receipt of approval from the government. The recommendation of the committee for upgradation of the post was from junior assistant to senior assistant was conditional. Since the conditional, that is approval by the authority, is wanting for a pretty long period, and the petitioner received his salary in the upgrade post, the secretary has stopped the salary in the upgrade post, but the vice chairman PDA has not made any order to stop the salary. In the said counter, it was also indicated that as per the Odisha Development Authority Act, the vice chairman is the competent authority in case of financial benefit. From this affidavit, we are unable to understand if the vice chairman is the competent authority as far as financial matters are concerned, and he has no decision taken for stoppage of salary of the petitioner. Why his salary has been stopped? The learned counsel for the PDA being asked to bring this to the notice of this court if there is any statutory provision under the Odisha Development Authority Act where under upgradation of the post require concurrence of the government. He failed to show us any provision to the effect. Our attention was drawn to Rule 6 of the Odisha Development Authority rules, which read as follows. That is the identical case in the present case.
Not also. Identical. You also can see last page of the order. Well, there the post was upgraded, but later on his salary, though he was upgraded to the post of senior assistant, but he was given the salary of junior assistant. That was the subject matter. While he was working as a senior assistant post, whether he is entitled to receive the salary of the senior assistant.
May kindly see page 13.
Kindly allow me complete. You kindly see the order which was placed. You first paragraph, second paragraph. The grievance of the petitioner in this petition in nutshell is that the petitioner joined as junior assistant on 2/11/98 under the Paradeep Development Authority and continued as such till 2007 when the said post was found to be justified. You also kindly see the mark. When the said post was found to be justified for upgradation to the post of senior assistant. Accordingly, a decision was taken by the committee held on so-and-so, and the petitioner started holding the upgraded post in the pay scale with all benefits as admissible from time to time. The said scale of pay was revised with effect from by order dated so-and-so, and the petitioner was also drawing the same till August 2010 when the order under Annex 8 was passed, wherein the petitioner's scale of pay was reduced to 6625. The reason for the aforesaid reduction in the scale of pay was not communicated to the petitioner, for which he has filed this petition. The counter affidavit has been filed on behalf of the OP number 2 by the Secretary PDA, taking a stand that the Secretary PDA has stopped the salary in the upgraded post from September 2010. So there was a post there, the post of junior assistant was upgraded. Here it is not the case.
Your Lordship may then kindly see page 12. Page 12. Page 12 is the recommendation. Your Lordship may kindly see the last two paras. Sri Boral is working as stenographer to the officer of Sri Class 1 cadre and has completed more than 14 years of service. So as per practice, Sri Boral is discharging the duties of senior stenographer. In view of the above facts and circumstances, the representation of Sri S.K. Boral needs consideration. However, a 3-member committee consists of the planning member PDA, ADM Paradeep and finance member comes Secretary PDA and rehabilitation resettlement officer may go into the details of the matter and recommend their views for consideration. Page 13 is important. Page 13. The post of junior stenographer of Paradeep Development Authority held by Sri Sarat Kumar Boral is upgraded to the post of senior stenographer in the scale of pay 4,750 to 7,500 with all financial benefits, Lordship.
That was never accepted by the government.
The government has no role to play. That is the subject matter of challenge the writ application where Rule 6 has been quoted. That is the sole contention which is accepted by this Honorable Court and the writ petition was allowed. Your Lordship may kindly see the internal page 2 of the order which I supplied, Your Lordship.
Yes.
Rule 6. Was drawn to Rule 6 of the Odisha Development Authority rules, which read as follows. There, before that, my learned senior has already read that the approval, that due to non-receipt of the approval of the government, the scale was reduced to 4,750 in the case of which I gave my lord Sushant Mahapatra. Referring to Rule 6, appointing authority, supervision and control. The powers of appointment, promotion and punishment of officers and employees of the authority other than those on the deputation shall vest in the vice chairman. Your lordship, the last page, in view of such, the upgradation of the post of the petitioner does not come within the scope and ambit of the provision of the aforesaid rule, for which it is the vice chairman who is the collector of the district who is empowered to take a decision in this regard. From the counter affidavit as well as submission made by the learned counsel for the opposite parties, we do not find any authority for the action taken by the Secretary PDA. Therefore, we are inclined to allow the repetition. Accordingly, the order passed under Annexure 8, reducing the petitioner's salary to rupees 6625, which says the petitioner entitled to get the salary of senior assistant scale of pay as he was drawing earlier, and all his differential salary be paid within a month from today.
No, so but in your case, in para 14,
my lord,
once you put about the letter,
my lord,
para 14 of your petition,
my lord, that is Annexure 5, which is impugned, lordship.
no, there it was only an order reducing the salary. Here
My
it
lord,
is rejecting your representation for upgradation. These are two different contexts.
No, there
there here your upgradation request itself has been rejected.
My lord, in that case also, in that case, lordship, may kindly see the order. First page.
Here.
First page. The grievance of the petitioner in the writ petition in the nutshell is that the petitioner joined as a junior assistant on 2/11/98 under the Paradip Development Authority, in short the PDA, and continued as such till 2007 when the said post was found to be justified for upgradation to the post of senior assistant. Accordingly, decision was taken by the committee held on 3/8/2007, and the petitioner started holding the upgraded post in the pay scale of 4,750 to 125 to 7,500 with all benefits, including usual DA as admissible from time to time. The said scale of pay was revised to rupees 9,300.
Here there is no question of the upgradation being reversed. There is no question here in Mahapatra's case,
my lord,
of any order of upgradation being reversed.
That
is the request for upgradation being rejected. That is not the issue.
My lord, kindly see the second para. A counter affidavit has been filed on behalf of the OP number 2 by Secretary PDA, taking a stand that the Secretary PDA had stopped the salary in the upgrade post from September 2010 onwards due to non-receipt of approval from the government. Here the finances are rejected. And subsequently, the year 2019, the Mahapatra and Sri Sarat Kumar.
Here it's not finance which is rejected. Come to para 14.
No, the Paradip Port Trust.
PDA itself rejects.
Yes, no, the government in the Housing and Urban Development Department, Odisha, wide letter dated 18/5/12 have intimated the government in Finance Department, Odisha, Bhubaneswar, have been pleased to reject the proposal for upgradation of junior stenographer to senior stenographer of Paradip Development Authority. In view of the above, the earlier office order dated 2011-2007 stands cancelled, and Sri Sarat Kumar Boral, senior stenographer, is allowed to work in the former post of junior stenographer in the scale of pay of 5,200 to 20,200.
Here, this is the vice chairman himself. Annexure 5 is by whom? Annexure 5 is a decision of the vice chairman.
My lord.
There was no such decision.
There, your lordship, the upgradation was cancelled, my lord.
Not by the vice chairman. In fact, if you read carefully internal page 2,
my lord,
it is clear that the competent authority, being the vice chairman, did not himself do it.
Yes.
Whereas here, he has himself stopped the upgradation.
He has simply stated that the Housing and Urban Development Department has rejected. But my specific case, as per Rule 6, which is quoted in the order of 83 rules, it clearly states that the vice chairman is the sole authority to take all decisions, your lordship. Otherwise, the lordship may call for the other file, your lordship, the Sushant Kumar Mahapatra file. Let me come along with this, your lordship. Because both are in a similar footing, your lordship. And in the year 2019, they have filed writ application for promotion to the post of personal assistant. Both of them had filed together, your lordship.
Their vice chairman was the competent authority, has not taken any decision for stoppage. Sir, in Sushanta Mahapatra's, the vice chairman had not taken any decision. In your case, page 16, it's under the order of the vice chairman.
Vice chairman referring to an order of the Housing and Urban Development Department, Lordship.
Yes.
Your Lordship may kindly see the averment at page at para 16, internal page 7.
Yes.
My specific case and my case is similar to Sushant Kumar Mahapatra.
No, sir. There, in fact, they did not receive any approval from the government, and the competent authority did not pass an order. So nobody took a decision there. Whereas in your case,
here, Your Lordship,
the government has rejected. On that basis, the vice chairman has also rejected.
Your Lordship may kindly see Annexure 1. Annexure 1, on my representation, a committee was constituted.
Yes.
At page 12.
Yes.
And the committee recommended for upgradation, and I was upgraded at page 13. That is from 2011, 2007. And Sri Mahapatra is also allowed to continue from 2007, Your Lordship. Both of our cases were together decided, Your Lordship. That is my specific case.
No. But initial part, what you say is correct. The second part is where the problem starts.
In
Sushanta Mahapatra's case, the government did not say anything. They kept waiting for the government to take a decision. Meanwhile, without waiting for the competent authority, that is, the vice chairman also did not pass an order to stop the
what a humbly submit.
Because the government was silent, the vice chairman did not do anything. This court said that the competent authority is the vice chairman. He has not said anything. You cannot therefore stop his
what I humbly submit.
In your case, the government has taken a decision. On that basis, the vice chairman has taken a decision.
Annexure 8 has been set aside. I do not have the copy of the writ application. Your Lordship may call along with that petition, Lordship.
There's no need.
Your Lordship may kindly see. Because both of them are working, and in the meantime, they had filed writ application in the year 2019 for promotion to the post of personal assistant. That was disposed of. Both of them he's working against the post of senior assistant. He's working against the post of senior stenographer, Your Lordship. In the year 2009, both of them together had filed a writ application for promotion to the post of personal assistant. That was disposed of. And by virtue of this order, Your Lordship, he is continuing in the post of senior assistant, but in the meantime, whether he has been promoted to the next higher post, I don't have any instruction on that, Your Lordship.
Sir, what seems to have happened is this. Sushant Mahapatra came earlier to this court.
My Lord.
On 9 January 2012, the stoppage of his salary was stopped. The reduction of his salary was stopped by this court. They probably took a cue from this order. This order was passed only because decisions had not been taken by the vice chairman.
What a proposal.
So by the time it came to you, the vice chairman took a decision.
Vice chairman took decision, but not independently as per Rule 6.
No.
Then, Your Lordship, what I humbly pray, Your Lordship, I'll move a representation before the opposite parties, citing all Sushant Kumar Mahapatra and all the things.
All right, do that.
Yes, Your Lordship.
The petitioner seeks leave to withdraw this petition with liberty to make a representation to the Paradeep Development Authority on the strength of the order dated 9 January 2012, passed by this court in petition civil 22531 of 2011. Bracket Sri Sushanta Mahapatra of the state of Orissa.
Only one thing, the interim order is continuing. That may continue till disposal of the representation, Lordship, because he is continuing virtue of interim order 28/9/2012. Lordship may grant me that because I am continuing the last 10 years.
Right.
In the meantime, whether I have been promoted or that, I do not.
It's made before 5th September 2012, which shall be disposed of after hearing the petitioner by the PDA, preferably by its vice chairman, within a month thereafter, until such time the interim order passed in this court on 28 September 2012 will continue. The petition is disposed of, is withdrawn, liberty is paid for in the above terms.
Weekly list item 20.
Lordship, we are appearing on behalf of the authority.
All right.
I may be pardoned to mention, my lord, item 24, my lord, I was there. None of yours.
You were there. You were not here, sir.
Sorry,
there are two judges here.
Sorry.
Please trust our eyesight.
Sorry,
please trust our court master. If you were here, we would not have dismissed it, sir.
Sorry, my lord.
And if you had got up and said what you are saying now, we would not have dismissed it.
Sorry,
so you have to wait, sir. Kindly let us proceed with the list. You wait.
Item number 27. In the item number 27, in this case, the virus of section 21A has been challenged to your lordship. Your Lordship might have remembered on that day, Senior Mr. Jagabandhu Shaw has mentioned one matter in that Imami paper mill. The identical issues have been challenged, and Your Lordship has fixed it on 22nd November 2022 in double PC number 6629/2013. Your Lordship, a bunch of matters also have been fixed. Your Lordship may kindly, because just now I have received also the rejoinder has been served just now.
We have filed the rejoinder, but it has not come on board. We have filed the
first time you're appearing in person.
After a long gap.
Sorry.
Correct. Rejoinder be brought in record. List on?
Your Lordship, 22nd November.
22nd November.
Along with 6629/2013.
6629/2013. All right.
Imami paper mill versus state.
All right. All right.
Obliged.
Oh.
Weekly list item 28.
This is your option. I'm the virtual.
I am for
mode.
the opposite party.
My lord, I'm the virtual mode.
Yes.
My lord, this matter, my lord, Mr. Ajit Kumar Chaudhary has passed away. I want to withdraw this matter to file a fresh REIT application, as there is an old management was taken over by Tata Power.
All right. Counsel of the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition in accordance with law. Disposed of his withdrawn liberty is petition.
I am for the opposite party.
Weekly list item 29.
Pardon, my lord.
29A, please, your lords. The order of cancellation of lease is under challenge, my lord.
Cell deed is of 1983, order is of 1987. So it's a case of remand.
That order
Yes.
included
All right.
page 24.
Counsel for the petitioner, you say the petitioner purchased the block in question from the original lessor by a registered sale deed dated
Registered sale deed dated, my lord. 19/8/83, my lord.
19th August 1983. That is prior to the impugned order dated 21st September 1987. Passed by the Additional District Magistrate Bhubaneswar in revision case number 739 of 1987, whereby the lease was cancelled. On the short ground that the said order was passed without notice to the present petitioner. It is hereby set aside and revision case number 739 of 1987 is restored to the file of the ADM Bhubaneswar, where it will be listed on 19 September 2022. Just upon that date, the petitioner will appear for the ADM Bhubaneswar along with the downloaded copy of this order. Up till such time, the ADM Bhubaneswar is requested to proceed with the said revision case afresh and dispose it off within a period of 4 months thereafter. Until such time, the interim order passed to this court on 7th November 2012 will continue. The petition is disposed of in the above terms.
Obliged.
Weekly list item number 30.
And also item 30 and item 37 kindly be urgent.
22nd November.
Weekly item 31.
Interim order to continue.
Yes.
How would you get it?
31.
37. Ballot item 31 is no instruction.
No instruction dismissed.
Weekly list item 32.
Item 32, my lord. The cancellation of lease by the ADM. Annexure 2, kindly have a glance. The inquiry report of SDO at para 1, the inquiry report of the SDO Bhubaneswar in this lease indicates the mistake of fact, fraud, misrepresentation and material irregularity of procedure. But in fact, the petitioner, the father of the petitioner has not appeared in the case. No notice was issued. I have mentioned in my writ petition, and there is no such report of the SDO. But in a litho order, so many cases have been order has been passed. In order was passed 87 in March 2020. Para 4 of my writ petition
No reply filed, Mr. Wadhwa.
My lord, the original record is there. I can produce, my lord. The service return reveals that the Kasinath Naik himself received the notice on 12th August 1987, father of the petitioner. It is there with me. I can produce for your lordship. He himself has received the
No, in the order it has been reflected, but actually
No, I'm filing the original case record containing the service return of the process server. He himself has received and he has filed.
my instruction is that he has
No, your
not
instruction is not correct. You are the son of Kasinath Naik.
Yes.
Kasinath Naik himself was alive when the case was heard. He himself received the notice and he has signed the service return in the back page on 12th August 1987. And it is written in Odia that I have received the notice.
Let them file on affidavit because
No, I am producing the original case
Yes, sir. We'll
record.
quote from the record itself.
Original case record.
Yes.
Yes.
You see, the original record produced by Mr. D.K. Mahathi, learned additional government advocate, shows that the petitioners that in revision
Petitioner's
case number
deceased
356
father,
of
Kasinath
1987, the father of the present petitioner, who was the original lessor, was served, Shri Kasinath Naik was served
on 12th August 1987.
On 12th August 1987. The endorsement of such service of notice is there in the file.
In the service return. That is the service
In the
return.
service return. Full stop. In that view of the matter, the main ground, the only ground in which the order has been challenged, namely that the petitioner's father was not heard, was not issued a notice and was not heard by the revisional authority, fails. Full stop. If despite service of notice, the petitioner's father did not choose to participate, the impugn order cannot be set aside on that ground. In fact, the impugn order does show that submissions were made by Shri Kasinath Naik in reply to the show cause notice, and that he had also examined the LCR. He had made submissions and was heard by the ADM. Full stop. Consequently, there is no merit in the present petition. It is dismissed as such. The interim order is vacated.
Report of the sub-collector is not there.
Yes.
Weekly list item 33.
In this case,
33, no instruction.
I am for the government company, my lord, HPCL, my lord. And it says for the petitioner, my lord. She says that no instructions.
Council petitioner has no instructions.
My presence may kindly be noted, my lord. I am for the opposite party. Obliged.
Weekly list item 34.
Item 34, my
Item
lords.
number
I
30.
filed an application for amendment.
Your Lordship, item number 34, Your Lordship, on the last occasion has directed me to file a reply to the IA filed by the petitioner, Your Lordship. Your Lordship, I have gone through the entire IA and the IA is a matter on record, Your Lordship. So Your Lordship may allow that IA and Your Lordship may direct to file, submit solve a consolidated read petition. And since the identical matters have been fixed on 26th August, Your Lordship,
All right. IA 4002 for the reason stated therein, the application is allowed. The consolidated writ petition be filed within 4 weeks. Then in the main writ petition, you say list on
26th August 2022 along with WPC number 2914 2019.
Yeah. All right.
Obliged.
Weekly list item 35.
My lord, in the virtual mode, my lord, no instruction is causal service.
All right. Dismissed. All right.
I am present for the opposite party number 6, man.
All right.
Weekly list item 36. Item number 36.
None appears. This is not possible.
Weekly list item 38.
My lord, I am for petitioner, my lord. But the petitioner challenged the award passed by the labor court.
Only 2 weeks time to file counter.
Only 2 weeks time.
2012 matter, sir.
My similar matter decided, my lord. So, my lord, set aside the labor court award and awarded a compensation 3 lakhs, my lord. Very similar matter and same organization, my lord.
Not similar. Not similar matter, my lord. Not similar matter, my lord. That was decided that first, with the inquiry fair proper, that was taken as a preliminary issue before the Law and Labor Court. And that was decided first. Thereafter, on the merit of the case, it was decided, and that merit portion they have challenged. And there, your lordship said there is no reason has given while deciding the merit of the case. So, your lordship taking into circumstance, your lordship awarded. But here is the case, my lord. All the issues are taken together.
We left it out. Same, sir. Identical.
No, my lord. That
Yes,
is
it's identical.
my lord. That is the first preliminary inquiry decided in separate Howard, and that was challenged by the workmen before this honorable court, and this honorable court held that the inquiry is fair and proper, then remitted back for deciding on merit. And on merit, when it decided, that was in favor of the management, and the workmen challenged that award, my lord. Here, your lordship, taking to stand that there is no reason has been assigned for a merit of the case, your lordship interpret the matter and then your lordship awarded. But here is the matter, my lord. There the person was acquitted, my lord. But here he was convicted, my lord. And here on the domestic inquiry fair and proper. And
there also it was held, it was proper.
Yes, my lord. But
on issues 2 and 3, there also no evidence was led. We said it is improper for the, he should have asked evidence to be led, and therefore, same, identical, sir.
Yes, no, my lord, not identical. Identical. One joint inquiry is held by for 6 workmen, my lord. A joint inquiry, and they have challenged the first inquiry, whether the inquiry is fair purpose of the preliminary inquiry, the order of the preliminary inquiry, my lord.
Yes.
Of the Law and Labor Court, where the inquiry is held fair and proper. Here, all the issues are tried together, and inquiry fair proper is declared, and on the basis of the grievous charges and the punishment that is legal and justified. Your lordship may kindly have a glance. And he has given purpose. He has not challenged the inquiry. Here, my lord, total award he has challenged. Means all the issues are taken together. But there the issue is separate. Inquiry is separately, that was held that inquiry fair and proper, that was challenged, previous writ application. And that previous writ application, your lordship held that is fair and proper, and they remitted back to Law and Labor Court to decide on merit. There the Law and Labor Court decide the matter on merit.
Come to page 23 here.
Yes, my lord.
On issues 2 and 3, no discussion of evidence, nothing.
No, that is, your lordship may kindly see. On fair to consider for all the material available in the case record, and this in my opinion.
One line.
Action.
No discussion.
Well, above.
No discussion.
Above, my lord.
No discussion at all, sir.
Yes, my lord.
No discussion.
The inquiry is fair, proper, and all the charges approved.
Sir, that is not the only issue, sir. Once inquiry is fair and proper, the justification for the dismissal must be discussed.
That is just
These are two different issues. Same thing was pointed out there.
When the Labor Court will interfere, 11A, if it is disproportionate to the punishment awarded to the charges, my lord. So, the previously inquiry fair, proper, and the charges were proved.
And on that basis, that is the punishment given, that is.
So you're
legally
completely
justified.
mistaken on this.
My lord.
You're completely mistaken. The fairness of the domestic inquiry is one issue. The justification for the termination of the services is another issue. All right.
Yes.
The law is very clear.
Yes.
After rendering a finding on fairness of the domestic inquiry, the Labour Court is expected to ask the parties to lead evidence and then discuss the evidence, give a finding on the justification of the dismissal.
No, my lord. If the all right,
Your Lordship, you may have that opinion, sir. You may have your opinion. No difficulty. You may not have the trouble to look into case law. We deal with these cases every day.
My lord, if all the issues have tied together,
yes,
then the Royal Labour Court to give a finding on all the issues. But if the workman taken or
anyway, there is no discussion at all on merits in this award.
If the management file a petition for taking the inquiry for the inquiry fair purpose, a preliminary issue, then that will be the issue will be decided first. Thereafter, the merit of the case, the Labour Court will call for the evidence of the both sides. But here, all the issues are tied together, my lord. When all issues are tied together, there is no question of going to the merit, my lord. My lord, I will file the some decision.
Sorry.
Because
the petition is allowed the same order.
When all the issues are tied together, how my lord, it will be?
We'll just come back in 5 minutes.
This case originates from proceedings, so motor cancellation proceeding of lease. Okay. And the petitioner, who is the purchaser preceding such cancellation, was not made a party.
That is sale deed is of 1980 and the order is 1998.
All right. Yes. See, the petitioner, the purchaser of the property in question from the original lessor by a registered sale deed dated 4th August 1980. Of the impugned order cancelling the lease has been passed by the ADM in revision case number 91 of 1998 on 30th June 1998 without notice to the petitioner. On that short ground, the impugned order is hereby set aside. Revision case number 691 of 1998 is therefore in the file of the ADM where it will be listed for hearing on 21st September 2020, on which date the petitioner will appear along with a certified downloaded copy of this order. The ADMs will proceed in accordance with law thereafter. And after hearing the petitioner dispose of the revision case within a period of 4 months, till such time the interim order passed with this court on 15 January 2013 will continue.
Gratefully, Your Lordship.
Weekly list item number 40.
May please your lordships. Lord, before going to the impugned order, I'll just take your lordships to the IPR policy. I have given the copies, Lord, of 2011. Just 2001. Just 2 clauses, my lords. If your lordships would see internal page 12 of that policy. Because unfortunately, that has not been annexed, so that's why I've given it separately. And my entire case relies on 2 clauses that I'll just point out to your lordships. Clause 13.5 at page 12. That's the time frame. A unit shall forfeit its entitlement to grant of incentive if it doesn't file its claim completely in all respects within 6 months of its starting commercial production. The power to condone the delay not exceeding 6 months in submission of the above claims shall vest with the Director of Industries, Orissa, while Secretary Industries shall be competent to condone the delay exceeding 6 months, maximum up to 1 year in that context. So I have to make the application in total within a period of 1.5 years, my lords, of my starting of production. And your lordships may then come to internal page 17, which deals with the captive power plant so far as the power subsidy is concerned. 18A, if your lordships would see, 1810A, I'm sorry, my lords. 18.10 capital A. That is, my lord, internal page 18.
Yes, yes, we have it. We have it.
Your lordship's got?
Yes.
Yes. Captive power plants in respect of which fixed capital investment has commenced within the effective period of IPR 2001 will be entitled to exemption of electricity duty payable for a period of 5 years from the date of commissioning of the plant. So, my lord, while considering my application, what is weighed while rejecting my application are two issues. First is, my lord, what I have raised is the decision which has been taken is supposed to be taken by the Secretary of the Industry Department, but a committee was formed for that purpose. I don't know why. And they have taken a joint decision not to allow it. And the consideration which has weighed with them that also the financial, the very purpose for which the IPR is floated, to give the financial benefit to the new incoming industry, the same has weighed with them to reject it. And that too by a committee, not by the secretary himself. So abdication of duty and the reason given. So that's why, my lord, I have my simple prayer subject to your lordship's consideration is, if your lordships can remind it back to the director or the industry secretary only, in terms of the IPR, he should take a decision on it, on my application. And so far as the delay is concerned, everything by giving me an opportunity of hearing. Because if your lordship should see annexure 9, that is the impugned annexure, page 55.
Yes.
And page 56 is the attendance of that committee, the next page. There's 7 persons, including secretaries and deputy secretaries of different departments, which is not the mandate of the, the IPR policy. And what has weighed with them, if your lordship should come to page 55.
No, the Secretary Industries is not part of this committee.
He is a part. He is a part.
He is a part of the.
No, my lord, he is there as a part. That is number 4.
Then?
No, my lord, I'll just, my lord, point out that he is to take the decision on his own independently, because the committee will involve other departments which will be affected. And that is the reason which has been given. If your lordship should just come to page 55.
No, assuming that he sat in his own chamber, but he got inputs from all of them, what difference would it make?
No, my lord, that is a different, my lord, aspect altogether, because, my lord, it is only on the condonation.
No, on your application for exemption from electricity duty, the Secretary Industries has to take a decision, right? That's what the clause says.
No, my lord, no. If regarding only the condonation.
Regarding condonation of delay, what he means to say,
department,
the first thing, the delay in filing of this application has to be condoned. And as per the IPR policy, the secretary is
to condone.
But here is a case where chief secretary has signed.
The committee has on merit has already rejected it. If your lordship should come to page 55, subparagraph.
So they've anyway not stopped at only delay. They've not said we are not condoning the delay.
They have also said, if your lordship says the finance secretary.
Like many of our orders, where not being satisfied with the delay, we nevertheless consider the merits, and then we say.
No, my lord, the merits which has weighed with them, that is why, my lord, I said the first very purpose of IPR is to grant the financial benefit. Now, it is the very same reason, if your lordship should see page 55,
yes.
It was observed by the company, the 4th subparagraph, if your lordship should just start with that.
Right.
It was observed that the company had delayed filing for ED exemption by 18 days if the date of commissioning of the plant is considered as 18th August 2005 as per the version of the company. So 18 days is by the Director of Industries, who was exempted also or recommended for exemption. I'll come to that. Then the next. The Financial Secretary wanted to know what would be the total financial outlay of the state if the condonation is allowed, and it was revealed by the officials of Energy Department to be approximately 10 crores. So this is the very purpose for which IPR is brought in, because they were to give me that financial advantage to the new industries. So if that has to wave in with them to reject, then, my lord, every industry, because the outlay for a mega project is very high always. If this is taken as the criterion for condoning the delay and then on this basis it is to be rejected. So that is my purpose. And if your lordship should just come to one more recommendation, which is given by the Director of Industries, which is that if your lordship should come to page 43. I'm sorry, my lord. page 45. Because if it is 18 days, then it is with the Director of Industries. And he has in fact recommended for the exemption at page 45 for condonation and exemption. Page 45, your lordships may come. Messi. The last paragraph. Because the IPR policy, as your lordships knows, is to grant the financial benefit so that new industries can be set up and they are not, at the very first instance, given certain subsidies. And the very purpose for which it has been given, the same purpose they have taken away. So lordships may see page 45 for a second.
So the delay here is 9 months and 8 days.
9 months, 8 days. That is why it went to the, should have been condoned by the secretary of the department.
But there in that letter which you showed down.
Yes, 18 days, because there was a dispute at that point of time, because we said the date of commissioning is concerned. We said it is in 2005 August. They said no, inquiry was set up. They said, no, it should not be 2005. The date of commencement will be not the actual production, but when the trial run itself starts. So on that basis, they counted the date, dated it to 2004. So that is why it became, the period became, instead of 18 days, it became 9 months, 8 days.
In any case, there is a delay which is liable to be condoned. That is also discretionary, not that it is mandatory.
No, I'm not saying, but then...
So, no, he's only saying put it back before the secretary.
Yes, madam. That can only be done if second. But one thing I would like to submit to your lordship, that so far as the merit of the impugned order,
that your lordship will not say anything.
So far as the merit of the impugned order is concerned, with regard to his entitlement to get the incentive, that is finally decided by the committee. So if that is set aside, then again it has to be, after the condonation of delay, again it has to be considered. So no order should be passed by this honorable court, which will influence the mind of the...
Either way. So
either way,
independent decision.
Obviously, that has to be there. I don't say that...
Because
the petitioner has challenged an order passed by the Chief Secretary, Government of Orissa, rejecting the petitioner's prayer for condoning the delay in making an application in terms of application for grant of exemption from electricity duty, correct?
Yes. Yes.
In terms of para 18.10 bracket A. Of the industrial policy of Orissa 2001, bracket IPR 2001. Decision dated 17 September 2012, the Chief Secretary, right? Mr. D.P. Nandan, Senior Counsel, the petitioner, has a twofold submission. The first is that the decision on whether the delay in filing such an application by the petitioner should be condoned had to be considered by the Secretary Industries in terms of para 13.5 of the IPR 2001, which reads under reproduce 13.5 to the plan. The second submission is that while dealing with the said application, a committee was constituted
under the chairmanship of Chief Secretary.
Yeah, under the chairmanship of Chief Secretary. And in the course of the deliberations, a query was posed by the Finance Secretary as to the open quotation total financial outlay to the state if such condonation is allowed, unquote. And it was revealed by the officials of the Energy Department that this would be approximately rupees 10 crores. Full stop. Mr. Nanda points out that the very purpose of granting exemption under the IPR 2001 was to give a financial benefit, and therefore that itself cannot be the reason for denying relief. Full stop. Paragraph. It is seen that in terms of para 13.5 of the IPR 2001, the delay up to a period of 6 months was to be considered for condonation by the Director of Industries, and for a delay exceeding 6 months up to a maximum of 1 year, it had to be considered by the Secretary Industries. Full stop. The said clause does not envisage a committee being constituted for that purpose. Full stop. In fact, this was noted in the letter dated February 2012, addressed by the Commissioner cum Director of Industries Orissa to the Additional Secretary Industries Department, while forwarding the case of the application of the petitioner for grant of exemption, noting that the delay was 9 months and 8 days. Full stop. Mr. D.K. Mantil on it actually commented on it, while not disputing that under clause 13.5, the IPR 2001, the question of condonation of delay beyond 6 months had to be considered by the Secretary Industries. Submits that this court should not express any view on the merits of the petitioner's claim for exemption, as that would have to be considered only after the delays, the question of condonation of delays answered. Full stop. With the paragraph, with the wording of para 13.5 of IPR 2001 being clear, namely that for a delay exceeding 6 months up to a maximum of 1 year in the making of an application for grant of incentives, it is the Secretary Industries who is competent to condone the delay, petitioner's application for condonation of delay ought to have been, no, the question of condoning the delay in the filing of the petitioner's application ought to have been considered only by the Secretary Industries. Full stop. On that short ground, the impugned decision of the Chief Secretary, dated 17th September 2012,
The decision of the committee,
chaired by the Chief Secretary.
Decision of the committee chaired by the Chief Secretary, dated 17th September 2012, declining to condone the delay, is hereby set aside, and the matter is directed to be placed before the Secretary Industries, who shall take a fresh decision on the issue of condonation of delay. Afresh, uninfluenced by the decision that has been set aside. Stop. In the event the Secretary Industries condones the delay, then the further question of
allowing the
incentive as paid for by the petitioner will be considered on its merits.
Yes. And one more, my lord, subject to your lordship's consideration. There was an interim direction by this honorable court because the energy demand was made regarding that period. So that should be, my lord, should not be insisted upon till a decision is taken.
And since huge amount of revenue is involved, I would like to pray your lordship to keep a
timeline.
Within 2 months,
exercise will be completed within a period of 2 months from today.
Yes.
Until such time, the interim order passed by this court on 30th October 2014 will continue. Petition is disposed of.
Weekly list item 41.
My lord, on behalf of Mr. Guru, no instruction.
Counsel, the petitioner states that she has no instruction. Petition is disposed.
Weekly list item 42. Item number 42.
None appears to sustain opposition.
Weekly list item 43.
Petitioner is not in contact since long, no instruction, so
no instruction.
Would withdraw to liberty to file.
Similar matters have been disposed of by my lords.
He's withdrawing.
My presence be noted.
All right.
Weekly list item 44.
Lordship, item 44, no instruction.
No instruction.
Weekly list item 45.
45, my lord, the similar matters has been disposed of and for the opposite party.
But there's none appearing, sir. None appears to sustain opposition.
Weekly list item 46.
None appears to sustain.
Weekly list item 47.
47, my lord, no instruction.
No instructions.
Weekly list item 48.
None appears to sustain.
Weekly list item 49.
May I please, your lordship? The petitioner was initially appointed as a non-formal facilitator in the year 1984, my lord. Well, here the petitioner has challenged the order of the learned tribunal under Annex 9, my lord. Kindly have a glance at page 38, my lord. The impugned order, my lord. Here my case has been rejected for abjuration as a regular primary school teacher on the ground that I was never appointed by the government, my lord. Lordship, may I kindly have a glance at page 39, the operative part of the order, my lord. Considering the submission made by the learned counsel for both the parties and keeping in view the fact that the applicant had never been engaged as an instructor teacher in any non-formal centers of the village run by the state authorities through a regular selection process, rather he was engaged by a voluntary agency to impart teaching in Prathamika Chatsali of the village, I am of the considered view that the relief sought for by the applicant in this way cannot be entertained. As such, I am not inclined to entertain this relief as has been sought for by the application in this way. The way is accordingly disposed of. Lordship, my case before your lordship is I was appointed under Annex 1 by the district inspector of school. My lord, it is completely erroneous on part of the tribunal, my lord, stating that I was never appointed by the. My lord, kindly have a glance at Annex 1, my lord, my appointment order. Annex 1, that is page 16, my lord. Well, this is my appointment order, my lord, issued by the district inspector of school, Anandapur, my lord. My lord, I was appointed in the year 1984, my lord. My lord, due to, my lord, the change of policy by the central government and due to reorganization of the scheme, the entire non-formal centers under the Anandapur block were handed over to the volunteer organization. The service of the petitioner was placed at the disposal of the voluntary organization, for which there is no fault on part of the petitioner, my lord. And my lord, while the petitioner was continuing in service, he undergone a city training which was sponsored by the government, my lord. And my lord, petitioner, basing upon the government circular dated, that is, my lord, Annexure 5, my lord, circular dated 1996, claiming for regulation of the service, my lord, as absorption as a regular primary school teacher. But you may kindly come to Annexure 5, that is page 22. The circular, but that is in Odia, my lord. But yeah, in page number 5, my lord, let me come to the page number 5. I've stated that, my lord, I've taken amendment, my lord. The non-formal facilitated teacher, supervisor, oblique instructor having CT B.Ed qualifications shall be observed as a regular primary school teacher, provided they fulfill the following conditions. A, the candidate must have passed matriculation examination and CT or B.Ed by the time the notification was issued, that is 19/8/1996. He must be in service, or else his case shall not be considered. Since the post of primary school teacher is a government post, the reservation principle would be made applicable to them. While appointing non-formal teachers, oblique instructor, supervisor, interest as senior will taken into account, my lord. I fulfill all these conditions, my lord. And my lord, this circular doesn't speak that if I was appointed by the by the third party or the volunteer, that I will never be observed as a regular primary school teacher. And my lord, my appointment is made by the district inspector of school under Annex 1. And my lord, the experience certificate is also there under Annex 10, which has been given by the Annex 10, that is page 41, inspector of school, my lord. Lords, may I kindly have a glance at Annex 10, page 41.
Yeah. What does the facilitator mean?
My lord.
What is the meaning of facilitator?
Sorry, my lord.
What is the meaning of facilitator? That is the.
My lord, there was a scheme, my lord. The petitioners were a non-formal facilitator. They were appointed a teacher under that scheme, my lord. That scheme was merged into NFE, my lord. Non-formal education scheme. My lord, both were central government funded scheme, my lord.
Yes, who's appearing for the? Yes, yes, Mr.
Well, I pray lordship can have a glance to that impugned order page 39 itself, which my learned friend has submitted with regard to the finding of the learned tribunal. I pray lordship can have a glance to considering the submissions made by the learned council for both the parties and keeping in view the fact that the applicant had never been engaged as an instructor teacher in any non-formal centers of the village run by the state authorities. So he putting harping on the engagement issued by the district inspector of schools. But he is not, another aspect is there. Two aspects are there in the finding of the tribunal. That the authority of the government and the non-formal education center. Here the engagement was given at voluntary under the voluntary organization.
No.
And that
come to page 41. This is issued by the office of the district inspector of schools, correct?
Yes, my lord.
Just read that.
Anandpur block from 2618.
So kindly read it aloud if you do not mind, sir.
My lord. This is to certify that Sri Bhagavan Pali, son of late Aditya Charan Pali of village such and such in the district of Keunjhar was serving as a facilitator at Janjali Upper Sai NFE Center in Anandpur Educational District under Anandpur block from 26/3/1984 to 22/9/1988. After projectization of the NFE project, he was transferred and joined on 23/9/88 and continuing as an NFE facilitator in NFE project under Secretary Dhakota Jubak Sangha voluntary organization till 31/3/2001, a period of 17 years and 5 days, including the period of government in service city training.
So this is issued by the district inspector of schools.
Yes, my lord.
So this is not
This
private agency or a voluntary agency or something.
This also indicates that he was engaged in the last. That I'm reading once again. Under Secretary Dhakotha Jubak Sangha voluntary organization.
Whatever.
So by the time was of consideration of the other.
Read the last one, sir, right from beginning. There's a period between 84 and 88.
Yes, madam. I do agree with the lordship.
He's transferred and he joins this NFE project on 23/9/88.
My lord, what is the prior to this, upon the scheme of the state government to absorb them as primary school teacher, they were working under the scheme funded by the central government. And under that scheme, this was the procedure that they are to be posted at different places. Looking into the closure
No,
of the
he's
scheme.
not engaged by a voluntary agency. Engaging is not by a voluntary agency.
No,
It's
my lord.
engaging by the state.
Engagement by the state.
So the OAT makes a mistake there. Rather, he was engaged. Just see the last 4 lines of page 39. Rather, he was engaged by a voluntary agency. That's wrong.
Just above that, what I read.
In fact, even that is wrong. That he has never been engaged as an instructor teacher in any non-formal center. It's not correct. He was engaged from 26/3/84 onwards.
Till 1988.
Yes.
And also.
And after that, he was transferred. He's continuing that till 2001. 17 years he's been there.
That is correct. And now your lordship may see his age, my lord, also.
That's right. He'll be 51 now. 56. It's all right. Whatever time he gets, he gets. The challenge of the present petition is to an order passed by the Orissa Administrative Tribunal, bracket OAT, on 18th January 2013, rejecting the petitioner's OA number 2040 bracket C of 1999. Whereby it prayed for a direction to the opposite parties, that is the School and Mass Education Department, bracket SM and E Department, Government of Orissa, to absorb him as a regular primary school teacher in terms of the circular dated 19th August 1986, with all service and financial benefits, with effect from the date his juniors had availed the same benefit. The background facts are that the petitioner was engaged in non-formal center initially by a voluntary organization which was managing the Prathamika Chatasalis in villages. After his claim for regular appointment was rejected by the Inspector of Schools, Tianjur, when order dated 19th December 1998. He filed the aforementioned OA number 2040 bracket C of 1999, challenging the said order. It is pointed out by the counsel appearing for the petitioner that after continuing for 4 years in the said Prathamika Chatasali at Janjali Upper Sahi under Anandpur block, the non-formal centers were merged in the projects of voluntary agencies operating the same block. And by a letter of dated 19th August 1988 of the District Inspector of Schools, bracket DIS, bracket Anandpur, the petitioner's services were placed on the disposal of the Secretary Dakata Jubaka Sangha. While he continued as such, he was sponsored for undergoing CT is what? What is CT?
What is CT? It is in abbreviated form. What is CT? CT means for?
EG.
CT.
Para 5 of your writ petition.
My lord. Let's get teachers training certificate, my lord. That is
CT training, that is it.
the certificate is annex under annex of 4, my lord. Second year teachers training certificate examination, my lord.
Sir, in para 5, you called it CT training. So I want to know what does CT stand for?
CT certificate of teaching, certificate training. That
No,
is
no, how can it be
after
certificate
plus
training?
2, they are to undergo that training course for appointed as primary school teacher.
CT training as an in-service candidate and passed the examination in 1993. Stop. Since he had become eligible to be appointed as a regular primary school teacher, he again approached the DIS for his absorption as such, in terms of the aforementioned circular dated 19th August 1996. Full stop. It is pointed out that in terms of the said circular, the following conditions have to be fulfilled for absorption as a regular primary school teacher. Take from internal page 5 of the writ petition. A, B, C, and D. Paragraph. The order dated 1912-98 of the Inspector of Schools states that the petitioner was serving only under a voluntary agency, and therefore his case cannot be considered for absorption. In the impugned order, the OAT appears to have adopted the same line and concluded under, take from page 39, last paragraph. Counsel the petitioner has drawn the attention of the court to a certificate dated 30th October 2006 issued by the DIS, Anandapur, which reads as under, reproduce the whole certificate at page 41. Paragraph. Mr. Mahapatra, counsel appearing for the SNME department. Refer to the counter affidavit filed in the present petition, which again appears to project the same stand, namely that the petitioner was engaged only by a voluntary agency, organization, and therefore he did not fulfill the requirement of the above circular dated 19th August 1996. Paragraph. The court finds that the conditionalities in the aforementioned circular dated 19th August 1996 appear to have been met by the petitioner, inasmuch as, in terms of the certificate issued by the DIS dated 30th October 2006. Petitioner was first serving as a facilitator at the Janjali Upper Sahi NFE Center in Anandapur Educational District for more than 4 years, between 26 March 1984 and 22nd September 1988. Full stop. Once this got subsumed into the NFE project, he became an NFE facilitator in the said project and served under the Secretary Dakota Jubaka Sangha voluntary organization from 23rd September 1988 till 31st March 2001. Full stop. By this time, he underwent CT training and also was fully qualified as such for being observed. Paragraph. The considered view of the court, the petitioner has fulfilled the conditions for absorption, and therefore his case ought not have been rejected by the impugned order dated 19th December 1998 of the Inspector of Schools. The challenge to which has been negative by the impugned order of the OIT. Paragraph. For the aforementioned reasons, the impugned order of the OIT as well as the aforementioned order dated 19/12/98 of the Inspector of Schools is hereby set aside. Stop. The opposite party SME department will now pass appropriate orders for absorption of the petitioner in terms of the circular dated 19th August 1996. Within a period of 4 weeks from today. The petitioner will not be entitled to arrears of back wages for the period during which he was out of service. Full stop. The petition is disposed of the above.
My lord. Weekly list item number 50.
The matter is infructuous. Kindly permitted to
The petition has been disposed of.
Weekly list item 51.
None appears dismissed. No prosecution.
Item 52.
May I please, Lord? Lord, here I challenge the demand. The demand has been made for the period for which my shop was not renewed and entirely my lord closed, my lord.
That's already covered then.
Covered that. No, that is a different. Your lordship can direct the excise commissioner to.
Correct.
He will
That's
file
standard
appeal.
order.
That order, the format order, your lordship is passing.
I think Mr.
almost all.
Patra's matters.
Because there are some factual controversies. We have
There is no factual.
we have filed our counter affidavit.
They have themselves said, Maharaj, in their letter that it was not renewed for the year 2012-13.
It is
And it was
better
not
the excise
renewed.
commissioners will examine. If he is exempted, he will be exempted.
The counter their letter, they themselves admit that, my lord.
The petitioner's prayer questioning the demand notice dated 23rd March 2013, bracket annexure 4, on the ground that the demanding caution money, MGQ duty, etc. for the financial year 12-13 on the ground that the petitioner's IMFL offshore was not operational during the said period will be examined by the excise commissioner. Bracket opposite party number 2. And after hearing the petitioner, a reasoned order shall be passed not later than 14 November 2022 and be communicated with the petitioner within a week thereafter. So, agreed by such decision, you the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of in the above.
The petitioner will produce this order before the excise commission for necessary compliance.
A downloaded copy of this order for the above purpose will be produced before the Commissioner of Excise on 29th August 2020.
Weekly item 53.
None appears dismissed from opposition.
Weekly list item 54.
My lord, I am virtual mode. Item 54, my lord, permit to withdraw.
Counsel petitioner seeks leave to withdraw his petition, dismisses withdraw.
Weekly list item 55.
Lordship, no instruction.
No instructions, dismissed.
Weekly list item 56.
And may I submit on behalf of Mr. Jena, my lord, the demand by the Annexure 5
Similar matter.
raised by the Superintendent of Excise Kendrapada for the period 2009 and 10, 8 and 9, though the petitioner has paid the entire amount during that period. No counter affidavit has been filed till date also. I have annexed the documents, Annexure 2 and 3, to show that the petitioner has paid the entire amount for the period.
Let me direct the excise commissioner. If he has paid, he will exempt it. Because these are all.
The petitioner has questioned the demand letter dated 22nd March 2013. Bracket Annexure 5. No, this is your representation. Sorry. Demand dated
Annexure
March
5.
2013.
Annexure 4 is the
Annexure 4. On the ground.
5 fixed.
You cannot challenge Annexure 5, sir. Annexure 5 is your representation.
No, page 31, my lord. Item 56. In 57, item 4, that is item 4. In item 56, it is Annexure 5. I am holding the brief of 56, my lord.
Oh, there are two cases.
Two cases, 5 cases are there, no, 2 cases.
I see.
Oh, there are 5 cases here.
Yes.
So each case is a different date.
Different date. That is different date.
All right. In all these, how many cases? 6 cases or 5? 5.
All against the demand
56
notice
to
issued
60.
by the excise
Five
superintendent.
petitions, challenges been raised to the demand notice served on the petitioners
By the excise superintendent Kendrapada.
by the excise superintendent Kendrapada for shortage of MGQ, for short drawn MGQ.
No, not only short down and MGQ, license fee and other
License
fees are
fee
there.
and license fee, etc. The plea of the petitioners is that they've already paid these dues for the aforementioned period, for the period in question. Full stop. The above plea of the petitioner shall be examined. You say, despite notice in the present petitions, no counter affidavit has been filed in any of them till date. So, on 13 March 2013, there was an interim stay of the demand, and that has continued since. Paragraph. In the circumstances, the court directs the excise commissioner, bracket opposite party number 2, to examine the plea in all these petitions, and after hearing the petitioners, to pass a reasoned order, not later than 21st November 2022. For this purpose, the petitioners will produce before the excise commissioner on 7th September at 3 p.m. downloaded copies of this order. The excise commissioners will dispose of the matters within 4 months thereafter, within a period of 4 months thereafter, until such time the interim order passed by this court in these petitions will continue.
Obliged. 56 to 60, my lord.
Yeah, petitions are disposed of in their own terms.
Weekly list item 61.
61 appeal is to be filed. You have to, your losses may condone the delay and relegate me to file statutory appeal.
All right. Counsel, the petitioner seeks leave to withdraw this petition.
Documents may be returned, my lord.
If such appeal is filed not later than 5th September 2022, accompanied by an application for condonation of delay, citing the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any view on merits. If the you say the original of the annexures be returned subject to substitution with attested photocopies there. The petition is disposed of is withdrawn with liberties prayed for in the above terms.
Weekly list item 62. 62.
Here also, sir.
The matter is infructuous, my lords. The matter is infructuous, my lord.
All right. None appears dismissal not brought.
Weekly list item 63.
63 matter is 3942. Your lordship historic judgment covered by case of automobiles, my lord.
In view of the judgment of this court in case of automobiles versus
Your lordship, it is covered only at page 17. It is in the assessment order. The observation is that the instant dealer has already been self-assessed 39. But whether communication has been issued or not, that clarification is not in the assessment order.
My lord, I have filed the order sheet. Your lordship may kindly see it at Annexure 4, page 20, my lord. Page 19. There was no any order regarding passing of the assessment order or communication of order to me. So this case is covered by your lordship's judgment, which has been upheld by the Honorable Supreme Court.
All right. In view of the judgment of this court in case of automobiles versus sales tax officer, bracket order dated 9 December 2021, in STREB. It has been upheld by the Supreme Court of India in its order by its order dated dash 1st December 2021 and STREB 64 of 2016. It has been upheld by the Supreme Court by its order dated 13 July 2022 in SLP Civil 9912/2022. The impugned assessment order dated 29th April 2013 and the consequential demand notices and other impugned notices are hereby quashed. The petition is disposed of.
Public.
Weekly list item 64.
None appears listed on opposite.
Item 65.
May I please, your lordship? My lord, I am to virtual mode, your lordship.
Yes, yes.
Here, my lord, the action of the OSFC demanding the amount in terms of the SFC Act was under challenge.
Yes.
They have filed a counter affidavit saying that I had made an OTS application which has not been entertained because of the fact that at the relevant point of time there was no scheme. Just let me clarify humbly. What has happened? I just took an instruction today morning. He says in addition to the condition that was imposed by the reasonable court with regard to deposit of 80,000, he has paid certain more amount, but he was called upon for a settlement. But because of the pendency of writ petition, he has not moved. I am only praying, subject to your lordship's kind consideration, that I will move the authorities for consideration of the amount and settlement, and I will, my lord,
there
I will make payment as per the decision of the OSFC. That's much I am praying.
Counsel, the petitioner on instruction states that the petitioner will move the OSFC.
I am for the opposite one, number one.
For consideration of his case under the extant OTS policies.
That is his prayer.
Granting the petitioner the liberty to do so, the petition is disposed of.
Deeply obliged, man.
Right.
Weekly list item 66.
My lords, I am appearing on behalf of my learned senior, Sri UK Samal. Here the matter has been rendered infructuous.
Counsel petitioner states the petition has been rendered infructuous. Disposed of as such.
Weekly list item 67.
None appears dismissal not also.
Weekly list item 68.
Madam, may I permit to raise this matter on behalf of Mr. Jana? And this is a matter where Annexure 11 is the order passed by the Principal Secretary, Housing and Urban Development Department in rejecting the appeal filed by the petitioner. They have taken a decision on the ODA Act, though the plan approval has been made as per the Municipal Act.
Here, in fact,
in their
BTA is the contesting opposite party.
Notice has
BTA is the contesting opposite party. Probably notice has
till
not.
that No page appeared. Instruction is notice has gone. If your lordship permit me, then I will submit a copy on the council APR form for BDA, my lord.
Although Bhubaneswar Development Authority bracket BDA is the main contesting party. The bracket OP number 2 is the main contesting party. It has not yet been served. Oh, Mr. Parth Mukherjee is appearing.
Who is appearing? His name is not reflected in the cause list.
Yeah, the name, just take off that order. I say the name of Mr. Parth Mukherjee, counsel appearing for the opposite party number 2, BDA, be reflected in the cost title, cost list. List on 11th October.
Interim order.
Interim audit.
Wiki list item 69.
None appears to system officer.
Wiki list item 70.
May I please, Your Lordship? My Lord, petitioner's land, house and house sites have been acquired for the purpose of Rengali irrigation project, but till date no compensation has been paid.
That you have to go under the act, sir.
My Lord,
Your name appears in the award. When was the award passed?
my Lord, initially the land belongs to one Gunjar Sahu. In the year 1996, she sold the land to one Sudarshan Khilar. Thereafter, in the year 2002, Sudarshan Khilar sold the land to the petitioner.
So when was the award passed? Let us go step by step. When was the section 4 issued? When was the section 6 issued? When was the award passed? No details, nothing. You better withdraw it and first do your homework and file a better petition.
Well, in the year 2002, petitioner filed one land acquisition case number 19 of 2002 before the opposite party number 4. Till date, that is also pending before him.
No.
How do you know that?
Well, page 14.
How do you know it's pending? And what is your prayer? Come to your prayer.
My prayer is to
just pay compensation.
Payment of compensation.
No details, nothing. Just pay compensation. That's it. No need to say when section 4 is issued. No need to say when award is passed. Nothing. What do you want to do, sir? Even extent of land, nothing, no description of land.
Lord, in fact, we have filed a counter affidavit in this case, and that page 4 of my counter affidavit may kindly be seen.
Yes.
8th line. On verification of the records of this office, the fact was found correct and it was revealed that award under section 11 of the Act in respect of such 40 decimal, that is the disputed land, has been passed in favor of Somabari Pradhan, wife of late Narendra Pradhan, and awarded amount of has been paid to the concerned awardee on dated 4th September 1980 by the then zone officer RIP so-and-so. The rent in respect of such 40 decimal has also been abated by direct case number so-and-so. The rest area of 11 decimal in Sapik plot number so-and-so, 6 decimal were converted to half plot number so. It was sold to Dukhabandhu Khilar, son of this petitioner, perhaps. Dukhabandhu Khilar. No, Panu Khilar is the son. Dukhabandhu. Dukhabandhu Pua na?
No, Dukhabandhu Pua.
So far as the disputed land is concerned, the award amount has already been paid. If he has got a claim, then he has only to raise the claim under section 30 before the civil court. That is also become time bad. But
He says he has already filed an LA case.
My lord.
Given some number. He says he has filed an LA case.
Then that can be taken care. LA case can be pursued.
You pursue that case, sir. Where is it pending? Where is that LA case pending?
Before opposite patent number 4. LA case number 19 of
Opposite patent number
2002.
4.
All right. If LA case number 90?
19 of 2002.
19 of 2002 has not yet been disposed of by the Special Land Acquisition Officer.
Not claimed to have been disposed of. I don't know.
If it
He
has
is
not,
saying that.
if it has not, say if it has not,
Okay.
the same be disposed of within a period of 6 months from today. A copy of this order be sent to opposite party number 4. Is it 5?
4, my lord.
4 is zone officer.
Zone officer.
That is what I am saying. That zone officer. What
Land acquisition case will not be disposed of by zone
it is
officer.
to be disposed of under reference to the
My lord,
civil
can
court.
My lord, page number 14. Zone officer called for the entire documents along with the.
But the LA case will be pending in the court, sir.
Civil court. You take instruction. What is the status? It is a year-old
Let him
case.
file a fresh petition.
Yes,
I
ma'am.
think that's better. You say counsel the petitioner seeks leave to withdraw this petition. Liberty to file a fresh petition in accordance with law. Disposed of is withdrawn with liberty. All right. We'll continue after lunch.
Well, may I want to make a mention, my lord?
Yes.
From the list, I'm very sorry because I'm not feeling well. That is what I'm making a mention at the time. Hearing item number 24.
Yes.
My lord, this matter may be called on after 4 weeks. The client is not yet ready for his hearing. While
Supplementary
hearing the
list.
bail matter, your lordship directed to hear the appeal itself. So, if your lordship he wants some more time.
Acha. At the request of counsel to the appellant. When do you want it, sir?
Well, after 4 weeks, any day, ma'am.
29th September?
That will fine, ma'am.
Oh.
My
The plan
lord,
will-
all prior your lordship, item 25
I
in
will
the
much obliged.
supplementary list. Item 25 in the supplementary list, your lordship.
Yes.
The counsel cannot appear in this case because he has got appointed as a APP. So I have instruction to appear and let's show and a fresh Bhinama is required to be filed, your lordship. So I pray.
This is ITA.
ITA, my lord. ITA.
Ah.
So I pray 2 weeks time, my lord.
All right. At the request of counsel, the appellant list on 29th September. No. List on.
I may be pardoned, my lord.
1 minute. List on 10th November.
Oblige, your lordship.
I may be pardoned. I am suffering from fever, viral fever, 102 temperature. Item 16 kindly adjournment. Supplementary list.
Item 68.
Item 16, my lord.
I see. Who's appearing on the other side?
Government is
Counsel for the petitioner stated to be on well.
Item?
Item 16.
Act on 23rd November.
Okay.
Quickly list. Item number 71.
No, close dismissal, no person.
Quickly list item 72.
May I please, your lordship? This item 72 will have.
The 72 minutes, the companion petition has been disposed of. And let's make see the order. 72.
Disposed of.
WPC 29170. The one that was tagged.
171 is different. 171 is different. I have supplied the copy of my lords. At the behest of the vendor, my lord. Vendor had approached my lord against a similar order. There, my lords has passed the order I have supplied. 29172. I am now on 29171.
I'm supplying also the copy to my land senior. So Lordship, kindly see the order. My Lord sitting with my Lord, it's my Lord Justice. BP Rautar, my Lord, I passed this order on 23rd March 2021, exactly in the same order at the behest of the vendor. I am the purchaser. I have purchased only 10 decimal land. My vendor also succeeded in his attempt in respect of unsold property. Before lunch, I had supplied. Yes. Your OP number 7 was the petitioner in the earlier case.
Same thing, more or less the same thing.
More or less the same thing. Let him go before the authority.
It's 23/2021.
Wiki list item 73.
May please, my lord. My lord, the petitioner has challenged the award of the industrial tribunal under Annexure 1, my lord. Now, even though the petitioner has worked with effect from 1/6/1991 till 28/2/2004, but he has been terminated from his service, and he has approached the industrial tribunal, where the industrial tribunal has rejected his prayer on the ground that he has not worked continuously for the said period, and the Management Animal Disease Research Institute is not coming under section 2J, that is in definition of industry of the ID Act, my lord. My lord, please have a glance to my lord, that is page 11 of the writ petition, my lord.
Yes.
In the petitioner has approached earlier has approached the labor court Bhubaneswar in ID miss case number 77 of 2006, where, my lord, the labor court has awarded in favor of the petitioner, and the same has also been complied. And now the industrial tribunal has held that it is not coming under the industry. Coming under the section 2J of the Industrial Dispute Act, my lord.
So,
no, that has been answered against the management.
Yes, my lord.
It has been held that it is an industry. Page 14. Therefore, in absence of sufficient evidence to exclude the first party management from the definition of industry, it would not be proper to exempt it from the purview of clause 2J of the Industrial Dispute.
Correct. So they've been held to be an industry.
And my lord, another ground of rejection is he has not continued. He was not in employment in continuously, but my lord, but we'll find from the exhibit 2, that is order of the labor court in ID miss case number 77 of 2006, my lord.
What is exhibit 2? There's no such exhibit 2 here.
My lord, it is available with me, my lord. If my lord will kindly have a glance to the para number 6, my lord. So, on careful consideration of all the materials available in the case record as discussed above, I am of the opinion that the applicant is entitled to get his arrear wages from the period from 1/3/98 to 28/2/2004. My lord, he has worked continuously.
No, that was earlier. This is about 1/3/2004 onwards.
And my lord, another in similar, in identical cases, that is in ID case number 41 of 2001, that was filed by one Babaji Charan Behera. Same case. In that case, the workman was reinstated.
Can be the same case, sir. You have to prove your case. Come to para 6 of the impugned award.
Yes, ma'am.
Please read it.
The claim of the second party workman is that he was refused employment with effect from 1/3/2004, but that of the management is that he has worked up to 31/3/2002. In support of his claim regarding management, the second party workman has filed the wage slips via Exhibit 3, which consists of 12 sheets. The said wage slips reveal his engagement up to March 2002. Another document, Exhibit 2, that is the copy of the order of the Labour Code Bhubaneswar in ID miscase number 77 of 2006 has been filed to show that he was awarded arrear wages up to 28/2/2004. But in this tribunal, neither the so-called wage slips reveal his engagement up to 28/2/2004, nor any other document has been filed or called for to substantiate the same. When there is no document in support of his claim to have been engaged up to 28/2/2004, and the first party management specifically says that the second party workman has not been engaged beyond 31/3/2002, it is best known to the presiding officer Labour Court Bhubaneswar as to how he was awarded wages for this said period. The schedule of reference is whether refusal of employment is legal and justified. First of all, the second party workman was not engaged till 28/2/2004, and as such, the said statement is a fabrication. So there is no scope for refusal of employment on 1/3/2004. Moreover, the second party workman having not come to the court of law in clean hand, he does not deserve any sympathetic consideration. Here, my lord, the Labour Court has held that there is no document in support of his claim to have engaged up to 28/2/2004, my lord.
Correct.
But my lord, in in ID miscase number 77 of
mere ID miscase will not become the document. You still have to show how you are engaged.
My lord,
after, because the management has taken a specific plea that you are not engaged after 31/3/2002.
My lord, in same ID miscase, the order, it has in para 5, it has been mentioned that on perusal of the case record, it appears that though the opposite parties have denied the claim of the applicant, but in Annexure 2 attached to the show cause has clearly mentioned that the applicant had worked under the opposite parties till July 2004. Annexure 5.
Why did you produce that document here? You should have produced that document here then. If you are confident that it actually shows your employment after 31/3/2002, could have easily produced that document here.
My lord, I may be granted at least 1 week time. I will produce this amount. And my lord, in the order, it has been.
Don't make it everything a ground for adjournment. All your submission should not end up in saying, "Give me adjournment."
My lord, but
this is a final hearing. It's not for adjournment. Yes,
but my lord, in this
should have been produced before the Labour Court, not produced here.
My lord, the ID miscase has been.
That by itself is not proof. If that award relied on certain document, that document should have been produced in this court. All right. The challenge is the present petition is to an award by the workman. Is to an award dated 24th August 2013, passed by the Industrial Tribunal, Bhubaneswar, in ID case number 56 of 2011. Paragraph. The following dispute was referred to the Tribunal for Adjudication. Take from top of page 8. The case of the workman was that he had been working as an NMR field attendant under the management from 1st June 1991 to 28th February 2004, and had completed 240 days in 12 calendar months prior to his refusal of employment, prior to his termination. He claimed violation of non-compliance with sections 25F bracket A bracket small b, 25G and 25H of the Industrial Disputes Act 1947. Paragraph. According to the workman, for non-payment of wages for the period 1st October 1993 to 1st September 1994, and again from 1st March 1998 to 28th February 2004. He had approached the Labour Court Bhubaneswar in ID miss case number 233 of 1995 and 77 of 2000, in which the Labour Court directed payment of his dues. Full stop. According to him, by virtue of the above order, the management. No, take that off. The above claim of the workman was refuted by the management. According to the management, he was engaged on daily wage basis from 1st May 1991, from time to time, with interruptions. And he was not engaged after 31st March 2002. As regards the issue concerning the engagement of the workman beyond 31/3/2002, the tribunal examined the copy of the order passed by the Labour Court in ID miss case number 77 of 2006. So, however, the wage slips produced by the workman himself before the tribunal did not show his engagement up to 28th February 2004. So therefore, apart from the copy of the order of the Labour Court, there was nothing to substantiate the workman's claim that he worked beyond 31st March 2002 up to 28th February 2004. Paragraph. Counsel the petitioner again referred to the earlier order of the Labour Court to urge that by itself was sufficient proof of the workman having worked till 28th February 2004. Stop. As noted by the tribunal, there is no supporting document to show that the workman continued till 28/2002/2004. If any such document was produced before the Labour Court, then such document ought to be produced before the tribunal in the instant case. Particularly since the management has disputed that the workman was engaged beyond 31st March. Stop. With the workman having failed to, workman as a claimant having failed to discharge the burden of showing his engagement up to 28/2004, the tribunal cannot be faulted in rejecting his claim for payment of his claim about the illegality of refusal of work after 28/2004 by the management. The court is unable to find any error having been committed by the tribunal, which calls for interference. Petitions accordingly dismissed.
Weekly list item number 74.
Question of law is at page 19, my lords. So already my lords have already decided this, my lord.
Copy. No, Your Lordship, recently, Your Lordship has decided this. These two questions have been decided. The question number 1 against the department and question number 2 in favor of the department. By cognizing the judgment of Honorable Full Bench, Your Lordship, what my learning seniors
Yes. So that's correct only what he's saying. The petition is disposed of in terms of the decision of this court in DCH Guruvalu Son and Company. This is sales tax of 2008 1 OLR 18. Combine the same terms.
Weekly list for orders item 75.
No.
Weekly list for admission item 76.
No.
Weekly list item 77. Item 78. Weekly list item 79.
Maybe. In form of PIL, my lord, the petitioner has paid for a direction to the state government for strict implementation of Drugs and Cosmetic Act by the retailer Medicine Shops, my lord.
Which shops, sir?
Medicine Shops, my lord.
No, which medicine shops?
Well, in the entire state of Orissa, my lord.
Please,
retailer.
We can't, this is not that kind of a PIL. You can't just go ahead, go against every medical shop in Orissa.
Specifically in Baleshwar, my lord. I have given the illustration, my lord. The persons.
It can't be illustrative, sir. You have to come mentioning specific shops.
Yes, sir.
You can't make allegation against every medical shop in the state of Orissa.
My lord, they are. It is your lordship may turn to. The state government has also accepted that this is going on, and they have also instructed your lordship may come to my please page number 35, my lord.
Yes.
Here the drug controller has categorically written, my lord. Please refer to this office letter number.
Who are 6 and 7? Opposite party 6 and 7. Who's that?
6 and 7, my lord, 6 and 7. He's not though he's engaged as Sikhya Sayak, but he is engaged in a medicine shop. That should not be. A registered pharmacist.
I go only against 2 people in the entire Orissa.
My lord, in Baleshwar, for illustration, I have given my third.
PIL can't be like this.
Actually, in the guise of PIL, they have targeted these 2 persons.
These 2 persons. I'm asking for the entire state, my lord. As per my lord, Rule 65, my lord, a registered pharmacist must be engaged in a medicine shop to supervise in distributing in selling the drugs, my lord. That is mandatory, my lord. That they are not doing. That is my only prayer.
That must result in something. What has happened as a result? What has happened as a result of these 2 persons getting engaged?
My lord, notices were issued, my lord.
What has happened? What adverse thing has happened because they were engaged?
Because, my lord, the registered pharmacists who are there unemployed, they are deprived of getting employment.
No. That's not the reason, sir.
That is also award, my lord.
No such person who was deprived of employment has come forth. Are you deprived?
Yes. He is the registered pharmacist, my lord, who has filed it.
Then it is not a PIL.
Yeah.
He is asking for the entire my lord, pharmacist.
No. Not possible, sir. No effective orders can be passed in PILs.
Well, your lordship may say that for strict implementation of Drugs and Cosmetic Act.
This is too wide a prayer. You can't have this kind of.
Well, your lordship
already taken care of. Annexure 5 is 7.
Yes.
What my
yes, that I am showing. In spite of that, they are not doing it.
Who is not doing it? Who is not doing it? You have
this drug controller has written to all drug inspectors, but that are implementing. Implementation is not there. Implementation is not there. That is my allegation.
There is a general instruction. There is a general guideline. Annexure 7.
Yes. That also I am saying that the direction is there, rule is there, not implementing it. That is my allegation.
You say the petitioner has a general grievance about non-implementation of the Drugs and Cosmetics Act throughout the state of Orissa. The prayers are framed in too broad a language making it impractical for the court to grant any effective relief. Sorry. The petitioner would be better advised to focus on specific instances of the adverse effects of the non-implementation of the Act and seek appropriate remedies in such instances. The petition is accordingly disposed.
Weekly list item 80.
Your Lordship, it is a PIL matter, my lord. The CDMO, Katak, he is going to construct a building over the road, Your Lordship. Over the road so that villagers they are aggrieved and they have made representation. Will Annexure 1. Annexure 1 may kindly have page 12. These two plots is particularly it is road. And it is covering this building covering half portion of the road. So it is inconvenient for the villagers to pass over the land. There is your Lordship, there is a specific plot is there. Annexure 2, it is meant for the construction of the health building of the health center.
Medical center.
Medical center. So my prayer is when reputation be considered and it is be constructed in some plots which is fit for this purpose. I accordingly made representation, Annexure 4 and 6, CDMO and collector. These villagers.
The counter already filed, sir.
Yes, my lord, counter.
Counter copy not been served. Benefit of the villagers, we say that it is inconvenient, the path is on the road. Annexure 2, Annexure 1, it is particularly page 12, recorded as Rasta, 2 plots. Plot number 1489, 1490. These 2 plots.
Annexure C/5 is the RI report that it is vacant land and the Rasta
No, but it says till now the khata has not been alienated in favor of the department.
No, it is not yet alienated. That is
And the proposal has not been accepted.
accepted by the
Then nothing remains. In the counter affidavit filed, it is inter alia stated in para 6.
Para 6.
That open quotation. Till now, the land in question, i.e. plot number 489 under khata number 1426 has not yet been alienated in favor of the requisitioning department, as the proposal has not been accepted by the sub-collector Sadar Katak, on the ground that the kism of the land being Rasta is not leasable, and to find out another leasable spot, unquote. In view of the above clarification, no directions are called for in the present petition.
Weekly list item 81.
Your Lordship, my submission is that in the ROR it has been recorded in the remark column that Rasta is there existed Rasta plot.
That's why they refused permission. Right.
Your Lordship, my representation be considered because in some other place the sub-center may kindly be which is fit for. There is a particular plot is there annexed to my lord, my land.
Order
Oh,
yes.
Item 81.
What the copy that is counter counter.
Weekly list item number 81.
None appears dismissal. Yes.
Weekly list item 82.
None appears dismissal.
Weekly list item 83.
I beg pardon, I am in virtual mode. Lordship, a very short question, but having public importance involved in this petition, Lord. That a pond having 2 acre 38 decimals, Lord, in ward number 57, coming under the Katak Municipal Corporation, Lord, is situated at village Gopalpur, Lord. And the municipality has also spent 13 lakhs rupees for renovation of that pond, Lord. But there is no road connection to that pond, Lord. So therefore, the villagers had approached the Tahsildar. Your Lordship can turn to Annexure 6 series, not as far as 43, Lord. The Tahsildar conducted an inquiry and the RI, through RI, and the RI submitted the report. Your lordship can see at page 46 with the sketch map. He has submitted the report. The villagers have filed the application, and 2 persons of the private plot, they are ready to donate their land for construction of the road connecting from main road to that village pond. Because the village pond is surrounded by all the private plots, Lord, and it is not convenient for use of the villagers as well as also for the purpose for which it was renovated. Lord. The lordship can see at page 46 the sketch map.
Yes.
But the 2 persons, that is opposite part number 6 and 7, they are ready to donate their land, but it was refused that it has been recorded as a Jalasaya. But it is never the character of Jalasaya, it was the Sarada. It was recorded under the Sarada. And in the meantime, my instruction is that the Commissioner Settlement and Consultation Miller has already converted this land to Sarada Miller. By way of an order passed on 24/3/2021. And there is no impediment for construction of the road. And in the meantime, the ADM, the sub-collector, all have recommended to the municipality, and you consider this report and construct a road connecting to the Smashan, the village pond, and the main road. Because it was not, there is no road facility to that pond.
My lord, what he is saying that it has now been converted to non-Jalasaya, that is not borne out from the record.
Yes, I'll file the affidavit. I have just got that order today.
In the alternative, the counter affidavit reveals that it is a Jalasaya, we have to preserve the Jalasaya.
No, it is not
if that is filed, I have to take the instruction whether what is the current status, whether it is already converted. But that is not part of the pleading.
I have to file my affidavit also.
All right. Consultation states you filing an additional affidavit within 2 weeks.
Yes.
List on 21st November.
Weekly list item 84.
21st November, my lord.
Weekly list item 84.
May I please, your lordship? Here in this writ application, my lord, the petitioner is challenging the modalities for collection of the user fees for the toll plazas for approximately a distance of 162.500 kilometers in such a cohesive and my lord, in a disparity manner that it will not only causing serious inconvenience but enhance the transport cost, my lord. Here the present petitioners, my lord, in the challenging the public notice under Annexure 3, my lord, Annexure 2, my lord, of the OP number 4, my lord, due to a concession agreement made by the government of Orissa, my lord, for construction of the road from Sambalpur to Raulkela, my lord. And 3 toll plaza were installed as per the my lord notification itself. If your lordship will find that Annexure 2, my lord, at page number 23, that one toll plaza on the right side, my lord, at Nuakhari Gaon, another is Mosanikani, and third toll plaza is lying. Here, if your lordship will find at Annexure 2, my lord, so far as the Mosanikani area is concerned, the toll plaza is invariably, my lord, is very high from the other toll plazas, which they have explained in the counter that due to distance, the amount has been enhanced. But so far as the petitioners specific plea that there is no modalities, my lord, has been fixed so far as collection of this user fees, my lord. Although in the counter they have explained so far as the user fees collections, but in the counter there is no whisper of a single word that what is the amount and what is the amount has been fixed per kilometer wise to collect this user fees, my lord. Here, your lordship, in the count, my case is that, my lord, the government has assigned this work to the L&T company on the basis of, my lord, BOFOT means build, design, finance and operate transfer basis to the OP number 4. L&T company has assigned the work, and here, as per the agreement, they will charge the user fees up to 22 years, which they have accepted all my contention in the counter. But so far as the modalities of fixation, they are saying that the third, the Mosanikani, the middle toll gate is admittedly it is distance of some kilometers. If your lordship will take the counter at point number
paragraph 10, internal page 10 of the counter. May placement.
But no amount has been mentioned.
It is to submit that the toll plaza at Nuwa Kurigaon toll plaza at Musakoni and toll plaza 3 at Lying have been installed in consonance with the provisions of Orissa State Roads Toll Determination of Rates and Collections Rule 2011. The rates have been fixed as per the rules taking into account the distance of coverage made by the said toll plaza. Accordingly, toll plaza number 1 covered a length of 45.69 km, toll plaza number 2 covered a length of 71.35 km, and toll plaza number 3 covered a length of 44.69 km of the project highway. Since the user fee is fixed as per the distance covered under the respective toll plaza, the user fee of toll plaza number 2 situated at Musakoni is higher than the user fee fixed for other two toll plazas. It is further submitted that all the local users with non-commercial vehicles residing within 20 km radius of any toll plaza are getting discount with monthly pass of rupees 210 only, which is very nominal amount to rupees 7 per day. The people residing 20 km radius of Sundargarh toll plaza are getting this discount benefit. Similarly, all frequent users who are crossing any toll plaza are also getting discount in the user fee with an amount of 2/3 rate of single journey for 50 times in a month. Hence, the allegation made directly.
But exactly, they have not given so far as the kilometer wise what is the user fees. Only in accordance with law they are charging, they are saying. But so far as the Mosanikani, if your lordship
not filed a rejoinder, so why should we go behind this? You have not filed a rejoinder.
My lord, the OP number 4 also has not filed the counter yet.
No, but this counter is already there. You could have filed a rejoinder.
I'll seek, my lord, 2 weeks time to file.
No. Everything doesn't lead to only adjournment, sir.
2 weeks time, my lord,
we're not granting an adjournment. Anything else you want to say?
No, your lordship, this is the...
All right, we'll dismiss. We'll pass the detail.
Wiki list item 85.
My lord, may it please, Your Honor, my lord. In this case, is a public interest litigation, and the petitioners are villagers, my lord. And last occasion, before the curse, what I remembered, we have alleging that some of the persons are forcefully occupying the land. So, Honorable Court Director, then you have to implicate them as a party, for which you will file a IA number 2574, so 2074, and naming the names that was listed today, my lord, along with this petition, my lord. The case of the people is that is schedule we have given 8 to 16. They are the person that has occupied the village land for which no development work has been done. And instead of this, this Tahsildar given a report that it was not encroached, it was free from all sort of encumbrances, and nobody has occupied the land. No counter has been filed by the state. And
where are the encroachers named? Where are the encroachers named in the petition?
No, they are included. They are included in the amendment petition.
Where is that?
That is IA
number 2574, my lord. Yes. 2252, my lord. 2252. 2-2. Was it allowed?
Lordship may see the 2574 of 2019.
You made a representation. I think better deal with the representation.
Yes, Lordship, you represent there. Annexure 7 series, but wrongly in the, I am sorry, my lord, in the counter. No, it's in prayer, it was written Annexure 8 instead of 7, my lord. Already the matter was vented to the different authorities and
there is no endorsement of
either it should be a Kalyan Mandap or the playground the students those are playing earlier. Slowly they are encroaching and there are
there is postal receipt, sir. The petitioner's representation stated 21st June 2017 and 24th January 2018, bracket Annexure 7 series, shall be examined by the Collector Baleshwar, and after giving notice to petitioners as well as to opposite parties. That is opposite parties 8 to 16. Were they allowed? Was it in application allowed? I'm not able to get that out. Was this application allowed, sir? Not formally allowed.
It was filed, but it was not taken for consideration because after a long period it was listed back. Yes. 2018 we filed the PIL application, my lord. Thereafter 2019 we filed IA. Thereafter it is not published.
Only once it came up in 18 and afterwards it not ever come up, sir.
Once it was listed.
Listed it was
come up after that.
Copy of the IA, state copy is there. I'm serving today. 2574.
It's an IA of 2019.
We have served copy, but I think that it may not be available.
As well as notice to the encroachers, alleged encroachers who have been named in the schedule to the IA number 2574 of 2019. And after giving them a hearing to pass a reasoned order. All right. What is that? Okay. As per the annexure to the representation dated 24 January 2018. And after giving them a hearing, the reasoned order shall be passed not later than 1st November 2022. The court clarifies it is not expressed in the matter.
Pastor matter item number 24.
May I please allow? My lord, the petitioner who has been working as a part-time guest instructor, my lord, he is working in Hirakud ITI since 2007. My lord, no counter has been filed, though my lord notice was issued, but in the meantime, my lord, some development has been taken place. And in some of the cases, this Honorable Court has interfered and passed the similar order, my lord. My lord, to go directing the opposite panel one to consider the.
Sir, he must be now 55 years old. The petitioner is 55 years old now.
Yes, my lord. He is continuing, my lord.
Why is it before a division bench?
Yes, that is in the single bench matter.
It's a single bench matter?
Yes, yes.
All right, let's before the roster single bench on 12th September.
Supplementary list. Supplementary list, fresh admission item number 1.
Yes, sir. Due to internet disturbance from our side.
All right, what's the main matter about?
Yes, my lord.
What is the main matter about?
Where the villagers, there is a bonus Suraksha committee formed by opposite parties. in our village, but our villagers are not in member of that committee.
What is that to show this representation was actually
Yes, my lord. Representation and accept 2 page 18.
No, what is that? What is that to show it was actually handed over?
Receipt, though there is no, there is no endorsement, but we present it before the opposite party number 3 office.
Not like that, sir. We'll have to get a stamp. We'll have to get an acknowledgement. Just see the CMA PLC for the reason stated therein the application is allowed.
Give us, my lord, maybe directed to present of the
31st January
petition as the representative.
And WP Civil 24481 of 2021 is restored to file. Then separate order, in WP Civil 24481. This petition has been restored today pursuant to the order passed in CMAPL so and so, permitting the petitioner to make a fresh representation, petitioners to make a fresh representations to the authorities. And after following up on such a representation, to pick appropriate remedies in accordance with law, the petition is disposed of.
Supplemental list, item number 2.
On item 2, I am appearing for Lordship. But in this matter, that entry 11 capital A is the subject matter of dispute. So far as the notification by Annexure 1 is concerned. If your Lordship looks at page 30, the Annexure 1, it at the English version is at page 33. The Ministry of Road Transport and Highways notification. Serial number 3 in the said rule, in Rule 81, page 33.
Yes.
Rule 81. I am concerned at page 34, Rule 11, that table C, 11 capital A.
Yes.
This grant and renewal of certificate of fitness for motor vehicle transport. This was incorporated older than 15 years. This refers to the levy of fees on 62(2) that I have also quoted. 3-wheelers, the first is motorcycle, 1,000 rupees. B is 3-wheeler quadrant cycle is 3,500 rupees. Light motor vehicle, 7,500 rupees. Medium goods and passenger goods vehicle is 10,000. Heavy goods or passenger motor vehicle, that is 12,500. Note is also the subject matter of challenge. I have also indicated the grounds to challenge note that additional fee of 50 rupees for each day of delay after expiry of certificate of fitness shall be levied. Your Worship knows this additional fee that was challenged previously in 2016 notification, that was a subject matter of challenging different data applications, and this Honorable Court has already quashed it. And Karnataka High Court is also, Madras High Court is also quashed it. But this 11A is also the subject matter of challenge in different high courts, where Karnataka High Court has already stayed it. If your Lordship looks at the order at page 7, page 91, that operation of the notification dated 4/10/2021 issued by the first respondent Annexure A is stayed till the next date. But I got the information it's still continuing, the stay is still continuing. The previous notification which was quashed is the subject matter in the Supreme Court also, page 89.
No, but between 4/10/21 and today,
yes,
this notification has been operational in Orissa.
This notification is operational in Orissa. Correct, my lord.
Then?
No, I have challenged it because actually the very notification itself is irrational, and this.
No, all that is fine. On the interim order, sir.
Right.
It is already worked out, and all of you are paying. Will only say all the payments may be subject to the outcome of the writ petition.
Lordship, other writ application or Lordship has passed the order.
Excuse me. So there are 2 other writ applications filed earlier. That is WPC 16497 of 22 and 16496 of 22.
That's right. That's what I've said. Any payment made is subject to the outcome. All right. Say notice If the party accepts notice for 1, Mr.
Yes,
P.
ma'am.
Behera for 3 and 4, opposite party number 2 is not necessary parties are accordingly struck off from the array of parties. Reply be filed. Consolidated cost title be filed within a week. Replies be filed within 8 weeks. Rejoinder before the next date. No date is given in these two.
Yes, madam. No date has been given. There.
We'll fix a date now. In IA number 9580, any payment of additional fee made by the petitioners in the meanwhile for renewal of fitness will be subject to the outcome of the petition. The IA is disposed of. Then say list along with 16496 and 16497 of 2022 on 21st November.
My lord, another 15 numbers are there similar, my lord. The Lord CV, I give the numbers that will become that. Well,
all right.
Both the items also, my lord, no date has been fixed, my lord. That
No, so now everything will come on 21st now.
Other matters are there, my lord.
All right.
Supplementary list item number 3.
I'm sorry.
Number 3.
But the petitioner here challenges the order passed by the Industrial Tribunal Bhubaneswar.
Yes.
That the impugned order finds place at page 13. If your lordship would kindly turn to 19/7/2012. The sought dispute before your lordship now projected by the petitioner is, prior to the handing over of the management, this particular institution took over this management on 3rd of October 2010. If your lordship would kindly turn to that page, I'll just request your lordship to turn to page 22 annexure 4. Lordship will see the entire document with regard.
Who's for the workman here?
Mr. Mahapatra is appearing.
I am appearing through virtual mode.
All right.
Lordship would kindly turn to page 22 annexure 4. This is the document with regard to handing over of the management between the previous management and the present petitioner management.
Right.
This 3rd of October 2000, my lord.
Yes.
And this document apparently contained a list of workmen, those who are working under the previous management and took over by the present management. Lordship will see the whole list exhaustively. It is there available on record. Now, what this petitioner did, my lord, this petitioner said that consequent upon, my lord, he raised the dispute that the present management is not permitting him to work, raised an issue of disengagement. Now, the term of reference, if your lordship would kindly see page 21, there is a reference, the date of alleged disengagement is stated to be in the reference May 2000.
No, so his name doesn't figure in that agreement.
Beg pardon?
His name does not figure in the agreement between.
No, doesn't figure in the list of the between the two managements.
All right.
And the term of reference, if your lordship sees, the term of reference is May 2000, which is prior to the date of taking over of the management. As the taking over management is October 2000 management.
Right.
And reference is May 2000, alleged date of disengagement is May 2000. Now, not pursuant to the reference, when the matter went to the tribunal, industrial tribunal, we filed an application there because the conciliation report and his statement of claim before the tribunal, he claims that his alleged date of disengagement is 20th of December 2000. Am I clear, man?
Yes.
But contrary to the reference date mentioned in the reference, he raised another date of disengagement, which will definitely connect this present management because that is after the taking over of the management. Now, to avoid that kind of ambiguity and doubt, let this present management filed an application before the tribunal, let the earlier management be noticed and let them be implemented as a party here. If a lordship would kindly turn to one order passed by the learned tribunal, well, I'll just request lordship to see that page 11, man. On my application, when issuing notice, the tribunal passed this order. Page 11. Last paragraph only, man.
Yes.
In view of the controversies narrated above, together with the anomaly relating to date of retrenchment, this tribunal considered it to be quite necessary to adjudicate the dispute in presence of the erstwhile management. Issue notice to Punna Patra, ex-MD, so-and-so, address. Now, it's a different fact that notice could not be made sufficient on account of lack of address or something like that. It can be published in the newspaper. But then, while deciding application, 19/7/2012, my application is being rejected saying that no, there is no requirement of erstwhile management being a party. So what I'm trying to tell you, Lordship, is leading to an inconsistent order, mutually inconsistent, because on the one hand, the learned tribunal itself has
Correct. So that's the only order challenge here.
That's the order challenge, not thereafter I filed an application to recall, learned tribunal rejected my recall application. This is a consequential order.
Yes, what do you say, sir?
My Lord, the learned counsel for the petition submitted that the date of retrenchment as reflected in the order of reference, that is to be taken into consideration for the decision of the case.
Correct.
But my Lord, kindly have a glance to the Annex 2, where the learned tribunal has categorically held that it is kindly, my Lord, kindly turn to page 17. It is true that, my Lord, last paragraph of the page. It is true that while in the scheduled reference, the date of retrenchment of the workman is stated to be May 2000 in the claim statement, the workman has placed that his service was terminated with effect from 21st December 2000. However, it is explained by the workman specifically stating in the claim statement that the copy of the complaint petition raising the industrial dispute before the labor machinery, the conciliation notice, the conciliation failure report invariably discloses that the alleged date of termination of the service of the workman is 21st December 2000. That is the reason why the learned tribunal has considered.
No, but you'll have to move for amending the terms of reference, sir.
Exactly.
The only solution is to amend the term of reference.
Yes, tribunal cannot go beyond the term of reference.
No, my Lord, kindly have in the next paragraph, the tribunal has come to a findings. It appears the month of retrenchment shown in the set of reference as May 2000 is a mere clerical mistake. The conciliation failure report reflects that the first party participated in the conciliation proceeding and did not take any specific stand as to when the second party was refused employment. Under such circumstances, it is to be concluded that it is no one's case that the refusal of employment took place from May 2000. That is the reason what they were assigned by the tribunal. While considering the pleadings of the parties as well as the failure report and the conciliation failure report of the made by the government. So, and in the meantime, almost 1 decade, 10 years has already elapsed.
Section 10.1, Section 10.4.
No, but is it a fact that the conciliation report refers to 21?
Yes, Lord. In the conciliation report, the alleged date is there. But in the reference, the date is something else.
Yeah.
Date is May 2000. But if a Lordship says, and coupled with the fact that the taking over management document and the list of workmen did not bear his name.
Correct. So,
and that's the reason I intend to implead the earlier management as a party. And learned tribunal, if a Lordship sees.
No. What is your claim, sir? Since when were you working with the opposite party, according to you?
Sir, I was working since
the SOC have filed, madam.
Past June 1989, and my service was confirmed as a permanent worker from 1st July 1990.
Then how come your name does not figure in that taking over document?
My Lord, that is the in what basis the list has been prepared. That is beyond my knowledge, because it is the
that's the reason his presence is necessary.
So, which is why the other management then becomes important.
That's the reason I say.
Yes, madam. If the management is implemented, I have also noticed.
Then the input order has to be set aside because it's on the short ground about impleading the other management.
Yes, my Lord, maybe time bound, time limit may be given. So that the matter may be.
You see, the short ground on which the impugned order dated 19 July 2012 passed by the Industrial Tribunal Bhubaneswar in ID case number 17 of 2011 and the subsequent order dated 30th August 2012. Rejecting the application by the petitioner for impleading the previous management as a party, as well as to the recall order dated
30th of August, Lord. That is 30th of August.
The recall order is 30th August.
1 second. I'm giving that date. No? That is 1 second. This is, yes, 30th of August 2012, page 16. 30th of August 2012. Man. Page 16.
Page 16.
Page 16, Annexure 2. Order number 21.
Is challenged is that the term of reference mentions the date of termination of the services of the workman to be refusal of employment of the workman to be May 2000. Is it? No date is given.
No date is there.
May 2000. Whereas the present petitioner management took over from the erstwhile management, the unit in question, on
3rd of
October 2000.
Right.
Good stop. It is pointed out by Mr. P.K. Ratha that in the schedule to the said agreement, there is a list of workmen whose services were taken over. And this list of workmen did not include the present petitioner, present workman, the opposite party workman. Initially, the tribunal appears to have accepted the plea and directed notice to issue to the erstwhile management by the order dated
10th of February 2012.
10th February 2012. However, subsequently, by the order dated 19 July 2012, it declined the prayer. Stating that unless the pleadings contained in the claim statement are amended to show that the erstwhile management is a necessary party, the tribunal would not be inclined to implead the erstwhile management. Paragraph. The petitioner's recall application seeking recall of the above order was dismissed by the second impugned order dated 30th August 2012. Paragraph. It is not disputed by counsel for the workman that in the schedule to the agreement, his name does not figure. Stop. However, he is unable to, he questions the omission of his name from the list. Stop. In order to explain this anomaly, it will be necessary to examine the erstwhile management. Stop. This is even assuming that before the conciliation, in the conciliation proceedings, the workman maintained that he had been refused employment on 21st December 2000.
Yes, ma'am.
And not May 2000 as mentioned in the term of reference. Stop. Paragraph. Since in any event, the erstwhile management is a necessary party to the dispute raised by the workman, this court sets aside the impugned orders dated 19 July 2012 and 30th August 2012 of the tribunal and directs that in ID case number 17 of 2011 pending before the tribunal, the erstwhile management. Now, what is the address of that erstwhile management?
That has to be ascertained, my lord, from the agreement. But the order sheet shows that they are not staying over there. Lord, it can be made by your paper publication if notices are not being sufficient against them. Page 22, the address is there in the taking over document itself.
The erstwhile management, that is Messrs. P.C. Patro and Associates, represented by Sri Purna Chandra Patro, will be included as.
May I just interrupt?
As
May
an
I just interrupt? Blood erstwhile management by name or the person in charge. Your Lordship may say nobody knows. Or the person in charge, whoever in charge.
Or the successor in interest.
Your Lordship.
Or the successor in interest. Whoever that may be will be a necessary party. Full stop. It will be the responsibility of the present petitioner to ensure service of notice on such party in accordance with law. Full stop. The interim order is accordingly vacated. The aforementioned ID case number 17 of 2011 will now be listed before the Industrial Tribunal Bhubaneswar for directions on 5th September 2022. The petition is disposed of in the above terms.
My lord, time limit may be fixed.
Considering the
case of my lord, 2011.
The tribunal is requested to dispose of the reference as expeditious as possible, and any event not later than 6 months from that date.
Dated 22nd December 2016, under answer 12 merit. I am permitted to place merit. The ground for challenging the annexer 1 is resolution regarding running page 40 regarding to that is to rehabilitate S12 easiest teachers as a Ganashikya minor. While they continue more than 6 years, government issued a resolution for regular observation, that is annexer 5 running page 52, giving scope to SC/ST person para 7, that resolution 5 regarding benefit for regular observation with 6 years.
Are there similar matters?
My lord.
Are there similar petitions?
No, my lord, no other
The first ever petition like this.
This petition has been filed by some of the candidates. They have filed being personally aggrieved. They sought for the relief that prohibition may not be granted. And after that order was passed, keeping in abeyance in respect of their case, these petitioners have come up before the court after 5 years of the notification. Your Lordship, that is your Lordship kindly have glanced page 36 of the writ petition, page paragraph 29. After the order was passed, they now coming forward. So there is no explanation for a period of 5 years. The notification was issued in 2016. They are filing the writ petition in 2021, and that too after interim order was passed in other cases. And they have enclosed another representation saying that the representation was submitted in 2017. There is no document that to whom it was submitted, whether it has been received or not. This is my preliminary objection. Thereafter, your Lordship.
My lord, it's a
What's the explanation of the delay?
My lord, it's a declarative prayer, my lord. So declare this even my lord, when the judgment of the London Tribunal directed to modified the resolution, that is annexer 5, my lord, and confirmed by High Court judgment of Honorable High Court, my lord. Thereafter, the present the impugned order, the addition of that is in the running page, that annexer that is 12, my lord, only modification of earlier resolution which was directed to be modified by London Tribunal, the judgment permitted place operate person judgment of the London Tribunal. In running page 74, para 12. In view of above, we hold that classification among the Ganashikyaks belong to general, those belong to AC and ST PH category related to benefits regulation violates Article 14 of the Constitution of India and is discriminatory as, and such classification does not satisfy the criteria fixed by the Honorable Apex Court. Accordingly, we direct the respondents to issue appropriate order modifying the order dated 4th December 2013. So
right.
that same is
reserving the rights
of the provision of Constitution of India,
opposite
which
party
is
to
confirmed
raise
by the Honorable High
the plea
Court.
of laches. Notice is issued. Notice is accepted by Sumapatra on behalf of opposite parties.
All the opposite party.
All right. Reply be filed within 8 weeks, rejoined to the next date. 28th November.
Supplementary statement note 6.
Meet result. Meet result.
So he.
My lords,
So this is a mistake.
There is a mistake, man.
He says it's the other.
No, my ground is, my lord, it is not because the Vibhasa Biswas scheme, as my lord senior is submitting.
You have given me the certificate.
That was no.
On
That
the
was, my lord, as per my instruction.
Yes.
That was for different period, and that is.
This is for 14-15, sir.
14-15 is correct.
Yes.
But, prior to that, in 2016, a scrutiny assessment was there,
And
based on which, my lord, demand was raised.
29/12/2016.
That was subsequently, my lord, ended with the Biswas scheme.
Yes.
My lord, as per Annex 2, my lord.
Yes.
Here, my lord, a phrase, the assessing officer, this is my instruction. But later, the assessing officer found another issue having escapement of income. For the for which notice was issued under section 1
You are giving immunity.
36/2021. Lordship rightly disposed of the matter, quashing the notice
You are not
back as per assessing the Supreme Court judgment, my lord, in Ashish Agarwal's case, my lord.
Lordship kindly
Because that was the for that same assessment year for two distinct periods, my lord.
Two distinct periods for the same assessment
No,
year for two different periods. I don't understand the statement.
That is my lord, on scrutiny assessment.
Scrutiny assessment was made on 29/12/2016. I filed an appeal. During the pendency of the appeal, this scheme came. Then I paid the tax, and your principal commissioner has granted me the certificate on the Annex 2 and under subsection 2 to section 5 matters. No reopening can be made. And in the counter affidavit, we have proceeded with Ashish Agarwal as that 148A, that Relaxation Act, etc., etc. You have never objected that this is incorrect. You have never given any objection to my pleadings. So, Lordship may kindly turn to the subsection 3 to section 5. Every order passed under subsection 1 determining the amount payable under this act shall be conclusive as to the matter stated therein, and no matter covered by such order shall be reopened in any other proceeding under the Income Tax Act or under any other law for the timing in force or under any agreement, whether the protection of investment or otherwise entered into by India with any other country or territory outside India. And after that, Lordship will kindly see Annex 2 at page 11. Their commissioner has given me the certificate. Amount is there, my lords. What amount tax as taxpayer? Then, my lords, the next page, page 12. Certificate number so and so, and their principal commissioner had signed it. He is the designated authority under this act, and he has I have paid the tax and I have raised an objection. Lordship will kindly see at Annex 3, page 14. Page 14, my lords. Again, the SIC has opted, Lordship may kindly turn to the bottom portion. Again, the SIC has opted for Vibhasa Biswas scheme for the above assessment year and paid all the taxes. Copy of Form 3 is a separate form.
This whole scheme is for
yes, my lord, my ground is, my lord, that because that has subsequently found that
no, but you can't. Once you have accepted this amnesty scheme,
yes,
it grants a complete blanket immunity.
Immunity.
I mean, my lord, I'll objection to more, my lord.
Order, we restore the petition, restore the interim order, let him file a reply.
My lords.
For the reason stated in the application, the order dated
11/7.
11 July 2022 is hereby resolved. And writ petition civil 21476 of 2021 is restored to file.
Matters. There is an.
And then in that writ petition, we say notice. Mr. Mahapatra accepts notice. He has filed a preliminary counter affidavit.
Yeah, and absolutely, there is no whisper that this is not covered under Vishwasa business.
Mr. Mahapatra states that he will file a reply specific to the contention of the petitioner that, in view of the certificate issued by the
principal
CIT under the Direct Tax Vivad Se Vishwas Act 2020, under section 5(1) of the Vivad Se Vishwas Act 2020, there is a complete immunity against any fresh notice being issued to the petitioner in any circumstances whatsoever.
Then interim application matters. They are now proceeding with the 148 proceeding.
Right. You said till the next date of hearing, no further coercive steps shall be taken against the petitioner pursuant to the impugn notice under section 148 of the Act.
Matters. Much obliged.
Reply be filed. The affidavit be filed within 4 weeks with advance copy to the counsel of the petitioner, who is permitted to file a rejoinder thereto before the next date. List of 5th December.
Supplementary Title Note 7.
Period for withdrawal, because subsequently landlord was pleased to pass an order on 19/5/2022, where is
Lord, same prayer, 2 writ applications, 2 PILs were filed. One was earlier disposed of by your lordships with the direction that the government should come.
My learned friend is incorrect. This petition was filed first. Thereafter, when public notice came, we filed second writ petition where this honorable court was direct on 19/5/2022, directing the Energy Secretary to give a complete hearing and will pass an order within.
That is already over.
8th August 2022. In view of that, I want to withdraw that.
You want to withdraw?
Ah.
All right. Counsel the petition seeks leave to withdraw this petition with liberty to file a fresh petition.
No, Lordship, because since it is
all right. Withdraw the petition. Dismisses withdrawn. All right. Dismisses withdrawn. All right.
Supplementary Title Note 8.
My lord, there are several writ petitions, all involving the same question of law.
There are several defects also, sir, in these petitions.
My lord, will kindly bear with me for a couple of minutes. The writ petitioners are real estate companies who are under trial, accused persons as of now under the OPID Act here at Cuttack. The Honorable Supreme Court, while granting these present writ petitioners bail, demanded of them a complete statement of the amount collected from the depositors, from amongst the public. It amounted to 63 crores and considered to by the Crime Branch Economic Offences Wing of the state as correct. Accordingly, the Honorable Supreme Court directed that amount to be deposited with the registry of the Supreme Court. Eventually, by an order by the Apex Court, that amount was transferred to the custody of the OPID court here in Orissa. Thereafter, under the mechanism of that OPID Act, under Section 3, there is a competent authority who incidentally is the Additional District Magistrate Cuttack, to whose account
this 63 crore rupees was transferred for eventual distribution amongst all the depositors. Now, while the facts stand at this, some of the customers who are complainants in the criminal cases and whose money is already collected by an order of the court, apex court, and which is under the mechanism, judicial mechanism for eventual disbursement, the process is on. Some of the customers are straying away to other forums like the RERA or to the consumer court for the same grievance and not a separate grievance. So when noticed, the present writ petitioners contended before the RERA court that whatever money was collected from these depositors is already custodial aegis and is under the mechanism of the OPID Act for eventual disbursement to them, for which public notice also has been issued. Now the question is, my lord, whether for the same grievance, maybe there are 3 or 4 types of forums available to a citizen,
Sir, we have,
like the consumer court.
Sir, we have listened to you now for patiently for some time now. We have listened to you patiently for some time now. We request you to listen to us now. Is he able to hear that? Is he prepared to listen to us?
Yes.
When are you going to remove the defects in the petition?
Let him serve a copy to
No, several defects are there, sir. It's not only about copies.
Copy may be served.
Several defects have been pointed out by the registry. When is he removing the defects? You ask him.
By tomorrow, man.
Counsel for the petitioner states that he will remove the defects within 1 week. List thereafter.
Supplementary list item number 9.
No instruction names.
Yes.
Item 9, sir.
Made legal.
Yes.
The petitioner has approached this court against the notice of 148 of the IT Act matter, which has issued on date 31st March 2021 matter. The very much circular is with effect from 1/4/2021 matter to 30th June 2021 matter. So it is covered by your lordship's decisions.
Yes, Mr. Chimaka.
Yes, my lord. Page 16. Considering the last paragraph, considering the above information, you have requested to give your response as to why the amount of 93,80,000 will not be treated as your income for the year under consideration, that is 2013-14, which is escaped assessment within the meaning of section 147 of the IT Act, and why notice under section 148 of the Act will not be issued. But this notice has been issued to 13-14, and in response to the Supreme Court order, Ashish Agarwal, after that, and after the
it has to go, sir. So it will go in view of Ashish Agarwal, it will go the same order.
It is prior to Ashish Agarwal case, my lord.
That's right.
It is Ashish Agarwal case for 1/4/2021.
No, he knows. That's right. Because of
So
Ashish
the notice
Agarwal,
issued
this Ambika Ayan will apply, sir.
My lord, it is 13.
You see, same order. That's same order.
Item 10.
My lord, in this case, my lord, your lordship in similar case, my lord, we have already issued notice and listed the matter on 8th September 2022. My lord. I am giving the.
All right.
Extra copy may kindly give.
No course of action. So demand is cancelled.
Notice returnable 10 September.
8 September.
8 September. In the next date, no course of action shall be taken. Mr. Petitioners.
Supplementary list for admission, item number 11.
Same order. Item 10. Orders.
Item 11, your lordship, kindly see the last order, 27/4/2022. Each honorable court directed to file the affidavit.
Yesterday, I have filed the affidavit by e-filing. I am filing today. I am filing the hard copy. I have sought the
So,
copy on my
Yesterday, he sought the copy. I will file the reply to it. Lordship may see the last order.
An affidavit has been filed today on behalf of opposite party number 2. What do you want to say, sir?
I will file the reply to it.
Alright.
It is not in consonance with the Honorable City Commission.
Alright.
I will file reply to it, your lordship.
Alright. Response thereto can be filed for the next date.
Your lordship, keep it to. My lord, your lordship may keep it to next week or
next week. No, we don't have that. No time. September is a working day. The working Saturday, 24th September.
Alright.
Supplementary list, item number 12.
That's, this case notes, I am for the petition.
My lord, I am filing a memo with regard to he has filed 3 missed cases.
That's IA number 14365 of 2018 is the petition for substitution matters of the defendant number, opposite party number 1, my lord. That's is required to be substituted by Nitish Kumar Panda. But in the memo, that's the counsel for the opinion number 1 states that Nitish Kumar Panda alias Nrutya Gopal Das, Jala of let Padmacharana Das, opinion number 1.
Chela, not Chela.
Yes.
So what should happen now?
Let's in the memo he has said that the council also understands to file the duly executed Bhaklandama in the name of Nrutya Gopal Das alias Nitish Kumar Panda. He wants to file the Bhinama. Bhinama has not been filed.
When are you filing?
I will file, my lord.
A memo submitted by counsel for opposite party number 1, stating that the name of opposite party number 1 should be written as Nitish Kumar Panda alias Nrutya Gopal Das, Chela of late Padmacharan Das. Counsel for the petitioner has no objection to the above prayer. It is ordered accordingly the consolidated cost title reflecting the change in name of opposite party number 1 be filed within a week. Paragraph. Counsel for opposite party number 1 states that he'll be filing Wakalatnama. These applications, can they be allowed or not? Substitution, all that.
Yes, that all things should be allowed. Therefore, I am filing. He wants to substitute me. Therefore, I am filing.
See, in that view of the matter, IA numbers
365,
367, 366 of 2018 are disposed of. List on. 14 November.
Interim order to continue, my lords.
Interim order.
Diploma.
Supplementary list item number 13.
May I please, Your Lordships? Lordships, I have challenged that Annexure 7, the order passed by the Honorable Additional District Magistrate Bhubaneswar in lease revision case number 885 of 1998, filed order dated 21/3/2012, my lord.
So there's already an order here. Just read the order.
Yes, Your Lordship.
Speaking order, everything has been.
No, the legal points has not been taken care of. The legal points is here before Lordship is once the lease is, my lord, granted in the year 1974, and can it be, my lord, initiated for redemption after 14 years or not? So law has already been laid down by this honorable court. Lease has been granted, Your Lordships, in the year 1974, and that for cancellation, my lord, it was initiated in the year 98 after 25 years. After 14 years, they cannot touch, Your Lordship. That is the decision of our own High Court. Your Lordship may kindly see this. Even if whatever fraud or everything is, my lord, alleged, that has not been taken care of by.
What do you say, Mr. Monty?
And Lord, your Lordship has passed several judgments following Vrindavan Sharma case. When there is a case of fraud and several leases have been cancelled in Bhubaneswar on these particular grounds. So fraud cannot stand on the way of this because it is a case of fraud where fraud has been perpetrated and the Tahsildar was put to task, he was suspended, put to everything was done. So I think my Lord has already rendered a judgment, Justice Patna.
Correct. We have passed subsequent judgments on Vrindavan Sharma's case. We have
Lordship,
followed Supreme Court judgment.
Your Lordship may keep it another day so that.
But even that Haripriya Visoy.
Haripriya Visoy and Vrindavan Sharma, these two.
Correct.
No, my lord, here, my lord, it is means para 9 of that judgment. If your Lordship may permit me to read that.
No. Both Haripriya Visoy and Vrindavan Sharma are after this judgment. They are Supreme Court judgments. Arising from Orissa only.
That is arising from Orissa State Abolition Act, Lordship, if I am correct.
Whatever, sir. They are arising from.
But here, my lord, it is your Lordship. For a moment, my lord, I may be permitted to read para 9 of that judgment.
Yes. We've read it. You can read it again.
Yes. Further, we find that the original lease was granted long back in the year 1974, whereas the revisional authority initiated the suo motu revision in 1998 after a long lapse of 25 years.
This is Haripriya Visoy case?
No. It is a case of Srimati Eli Patnaik.
The year?
2012.
2012
to CLR 826. 98, after a long lapse of 25 years, under second proviso to section 7A3 of the Orissa Government Law Settlement Act, no proceeding can be initiated after expiry of 14 years from the date of order granting lease. While prescribing the period of limitation, the legislature, while drafting the Orissa Government Land Settlement Act in their wisdom, prescribed the period of limitation for initiation of a proceeding in examining the correctness of the order passed under the Act, and also to find out if any fraud or misrepresentation etc. was practiced in obtaining an order. Being cognizant of such contingencies, the period of limitation of 14 years has been prescribed. The reasons assigned by the Additional District Magistrate Bhubaneswar about the fraudulent declaration made by the Digambar Behera in that case, that he belongs to scheduled tribe community and fraud was practiced to get the land settled in his favor can be decided by the revisional authority as per terms of the provision, but without the period of limitation. So the same allegation is leveled against me.
In how? My learned friend is perhaps relying upon that Odisha High Court decision.
No, this is the 2013 substitution. It's different, sir. Now the provision has changed. 7A3 has changed.
No, it's before before that provision, Your Lordship.
So
these incidents are before that provision. So whatever act, my lord, enactment was there before at the time of that granting lease, that will be applicable in this case.
No.
Now there is no 14 years.
That is already amended.
After 2013, there is no 14-year.
2013.
No, my lease was granted in the year 1974.
No. It's about the exercise of the power of
exercise of the impugned power.
That is in the year 98, Your Lordship. Here is the order was passed. The initiation of that proceeding was, my lord, revision was initiated in the year 98. And lease was granted, my lord, in the year 74. So after 25 years. The law says after 14 years, they cannot touch, Your Lordship. 7A clause 3. By that time, that law was there.
But we've distinguished this very judgment. I think you have those other orders.
That Harapriya Bisoy and
no. The orders passed by us.
That order, my lord, Justice Patnaik has passed that order.
No, do you have copies of that?
No, rightly, I cannot. Right now, I cannot provide that order.
So why don't you produce that, sir, before we pass an order on this?
By tomorrow.
Mr. G.K. Mantilan, AGA, states that you say, counsel for the petitioner relies on the judgment in Srimati Eli Patnaik versus State of Orissa, 2012 2 SCLR 826, which was in the context of the proviso to section 7 capital A bracket 3 of the Orissa Government Land Settlement Act 1962, whereby the grant of lease could not be reopened, even on the ground of fraud, after a period of 14 years after the grant of such lease. Mr. Manti, on the other hand, states that there are other decisions of this court holding to the contrary, which he wishes to cite. List on. September.
Supplementary Title No. 14.
Asa Hans versus State of Orissa.
Sorry?
The decision Asa Hans versus State of Orissa.
But you'll have to get the copies.
No, my lord, Justice Patnaik has written this judgment in this division bench.
Yeah.
That I will give.
Item 14.
May I please, Your Lordship? Well, in this case, all the opposite parties have filed their affidavits, my lord. I will file a dead charge, my lord. A comprehensive dead charge.
I think the Sambalpur Municipal Corporation.
Yes, madam. I also affidavit filed, my lord.
Sorry?
Yes, I already filed on 13.
What about Berhampur Municipal Corporation?
Newly added Berhampur.
No, the Berhampur Municipal Corporation, who's representing? Anyone representing Berhampur Municipal Corporation?
Yes, my lord. Notice has been sent, my lord. By the register.
Who's representing them? Has it been served? In the Rourkela, who's appearing for Rourkela Municipal Corporation?
I am appearing for the.
You had said that sewage pumping station Udit Nagar, Chained and Pradhanpalli will be completed before 30th June.
That has been completed and that is functioning, my lord.
Yes. Saying that Sambalpur Municipal Corporation, you have said there is a stay order in writ petition civil 34915 of 2021.
Yes, my lord.
That stay is not vacated yet.
No, my lord.
Did you move the IA? That's what you had decided to.
Okay.
Chief Engineer OWSSB requested to take steps for vacation of the interim order. Who's OWSSB? Mr. Monty, you are appearing for OWSSB.
Well, it's Sendas is appearing. I am appearing on behalf of it.
No, there was a writ petition civil 34915 of 2021. According to the Sambalpur Municipal Corporation, because there is a stay granted in that petition, they're unable to complete the sewage treatment plant. 2 sewage treatment plants, they had to be set up in Hirakud and Burla.
I'll check the status of.
Have you noted the number? Writ petition civil 34915 of 2021.
Please minutes.
You were the chief engineer, OWSSB has been asked to take steps to vacate the interim order in that.
I'll take instruction.
Is there any council who normally appears for Bahrampur Municipal Corporation here?
Mr. Ramesh Sahu. Ramesh Chandra Sahu appears.
Ramesh Sahu.
Ramesh Chandra Sahu.
None appears for the Bahrampur Municipal Corporation, despite service of notice. It is stated that Mr. Ramesh
Chandra Sahu.
Ramesh Chandra Sahu, advocate, usually appears on their behalf. Mr. Kirod Raut states that he will serve a copy of the petition on him before the next date. He further states that he will prepare a summary of the affidavits and file a written note of submissions by the next date. Tenth October. Published.
Supplementary item number 15.
In fact, item 15, the matter was dismissed for default, and that CMAPL I filed my power. In the main case, I pray for next week any day, so that in the meantime I'll take.
Sorry, I don't understand,
yes,
sir.
The matter was dismissed for default, and I filed CMAPL, and it was restored, and so far the main case is concerned, I do need to file a power. I pray for next week any day. So
What's the matter about, sir? Why keep adjourning?
The matter with regard to that bifurcation of parent Panchayat Samiti and creation of that new Gram Panchayat Samiti in the district of Nuapada. And
again, representation.
Yes.
So this is an old representation 2015, sir.
Yes. You'll also dispose of the matter, giving liberty to the petitioners to agitate the same for OP number 1. Then OP number 1 is to take a decision in accordance with law and other.
Or counsel for the petitioner seeks leave to withdraw this petition with liberty to the petitioners to approach opposite party number 1 in accordance with law. Disposed of is withdrawn, liberty is prayed for. All right.
Supplementary list item number 17.
And OP number 1 is to take a decision by giving opportunity of hearing to petitioners. That because Nuapada block comprises of 5
different. If such representation is filed not later than 19 September 2022. OP number 1 will give the petitioners a hearing and dispose of the representation with a reasoned order within a period of 3 months thereafter.
Yes. Item 17.
Item 1. 17. Sub item 17.
Cuttack District Tennis Association.
The question framed at page 5 and 6.
What's the delay here?
Delay, I filed the.
How many days?
Miss case filed for contention has been filed on 22 to 2019. Delay in filing up IT due to strike.
90 days. All right. The reason stated the delay is controlled. IT 151 of 2018. Yes.
Page 6. Question number E is important. Whether the facts and circumstances case the learned IT is correct in considering that 2LA registration can be granted to society activities of which are not involving charity element except commercial nature. The Commissioner of Income Tax rejected the 2LA registration matter because the Cuttack District Tennis Association involves not in charity.
1 minute, sir. Notice is not gone in this. No, notice is already issued. Anyone appearing, Mr. Rai, are you appearing this?
No, I am for the cricket as well.
Second and third.
You're in which one matter, sir?
Sir, I am in ITA 55.
56.
I am holding friendly match between the bench and the bar. And I don't know why Mr. Chimaka is opposing it. And he is like Dennis Lilly Mallards. Once he plays, he will get a chance in the IPL.
No, but who's appearing for Cuttack District Tennis Association? Has notice been served? Tracking report is not found. Sir, Cuttack District Tennis Association is around the corner, sir.
Cuttack. Party Stadium.
You should be able to serve them.
I've already filed requisite.
No, not there, no tracking.
We don't have tracking report. You see, fresh notice be issued to opposite party. Returnable on a longer date. 14th December. We'll take it up all on 14th December.
Well,
all right.
but their appeal has become infructuous, my lords.
Why?
They have already granted me registration.
Oh,
no.
Yes. I am giving you the copy. Your commissioner inquired, your CBDT has granted me. I am supplying the copies, my lord.
That not related to that assessment year.
Which assessment year?
Which assessment year to 22 to 23, 27.
It will relate back to that.
No.
Yes. Once you give now they're, my lords, previously they are saying commercial. Now they have granted me the certificate back because my activities are public utility.
No,
yes, you have. Yes.
Assessment here.
I know. Clause 8. Clause 8. Yes.
My appeal.
Your appeal, but you have granted me the registration certificate. You are now.
It is for 22, 23 to 26, 27. 8. Assessment or year for which the trust or institution is provisionally registered.
Yes.
Not prior to that. And my assessment is different assessment here.
Which you rejected, Malus, their commissioner rejected, the Commissioner of Income Tax Exemption rejected the application that my objects are not charitable. And now they gave the certificate of registration and they now say that yes, You are, after inquiry, you have given me. And Lordship will kindly, their own CBDT has issued a circular that sports activity.
Mr. Chimaka, any change in the circumstances, what you have to tell us?
Yes. Change in the circumstances, no change in the objects, my lords. No object has been changed.
No, activities.
Activity remains the same. That is why, my lords, they have given the certificate. And in 2000.
Let him examine it. Okay.
Yes.
All right. Mr. Rai points out, it has handed over copy of the order for provisional registration in Form 10 AC, granting registration to the respondent under Section 12 Capital A of the Income Tax Act 1961 for the years AY 2022-23 to 2026-27. Mr. Roy accordingly contends that the present appeals, this is in the ITA 55 and 56, have become infructuous. The issues raised in the present appeals have become academic issues. Mr. Chimaka states that he will have to seek instructions.
Instruction number WPC 18701 of 2016. They have filed appeal. Writ appeal before this honorable.
Writ appeal.
Writ petition, my lord. That is pending. Then will be called with this ITA.
All right. List along with writ petition
18701 of 2016.
18701 of 2016. Okay. Same date. What is the date again?
14th.
14th December. All right.
Supplementary list item 18.
In this case, I am for OP 2 and 3, I am filing the counter today and serve the copy to the petitioner.
I have the main just now, my lord. Main contesting party, opposite party number 1 did not file their counter.
Union of India.
Since we have challenged the ultra virus in Article 14, my lord. Let them.
Yes, Mr. Party.
Yes, we'll set up time to file them.
On last occasion.
Last opportunity to the Union of India to file a reply within 4 weeks. Counter has today been filed on behalf of opposite parties 2 and 3. Rejoinder be filed for the next date. 13th December.
Supplementary list item number 19.
19 minute, please, your lordship. My lord, this is a PIL matter, my lord. My lord, 1 week's time may kindly be granted. We have sought for instructions from the petitioner, some additional information, my lord. If your lordship may be gracious enough to grant us 1 week's time, my lord.
All right. At the request of counsel, the petitioner list on 30th November.
Supplementary list item number 20.
So this is a PIL challenging the public hearing held on 22/11/2022, 21.
My lord, in this case, last occasion, my lord directed to file the counter. Wrongly, my associate has given a draft counter which is prepared. Proper counter is required to be filed. Let's give some more time.
No, my lords, the short question here is whether the public notice was issued, held as per procedure, my lords. My lords, if my lords will go to the first order that my lords had passed, my lords had directed the ADM, which is the responsible authority to conduct the public hearing. The ADM has filed a counter affidavit long back, setting out exactly what was the procedure which was followed. And during the pendency of that, my lords, the EC was stayed. Therefore, my lords, I'm at.
Whom are you appearing for?
I'm appearing for the
Company.
private party, my lords, opposite party 8.
8. Huh.
My lords, that affidavit has been filed a long time ago. Rejoinders have also been filed. So that
No, but the government of India was supposed to file an affidavit.
my lords, the MOEF does not conduct the public hearing. The authority that is to conduct the public hearing, as per the EIA notification, Appendix 4 is the ADM.
No. We explained in 10th March why the MOEF is essential.
My lords, if my lords would have the first order, 8th of February 2022.
No, 10th March. 10th March, you see, you've said it's essential for opposite party number 6 to file an affidavit.
My lords, I'll explain why that happened. That was because I made a submission because during the pendency of this writ petition, my EC was not being granted. The EAC was not holding its meeting. Therefore, my lords directed the MOEF, which is the appropriate authority for grant of the EC ultimately after the public hearing is already over. to state on affidavit what is the procedure, what is the status of the grant of the EC. However, the authority which holds the public hearing or conducts the public hearing as per the EIA notification is the ADM. That comes from the first order, my lords.
Let the MOEF file an affidavit. You say Mr. Party, Learned Counsel appearing for the MOEF, states that he'll file his affidavit by
4 weeks, man.
My lords, that's a lot. He's saying that it's already in the draft form, my lords. My lords, I am at a standstill today because of
We
this.
require that this draft would be filed blindly. It cannot.
within 4 weeks as a last opportunity. All right. Rejoinder there to be filed by any of the parties before the next date.
Well, that extends
My lord, fixing the debt, my
further.
lord.
2 weeks and 2 weeks, my lords. If my lord seems it appropriate.
Fixing the debt, my lord. Any debt.
Sorry?
My lord is fixing any debt, my lord.
Yes, yes. First November. All right.
Interim order.
Yeah. Into continue. Right.
Supplementary list item number 21.
May it please this honorable court. In this matter, we have just been served with a counter affidavit. We request some time to file a rejoinder.
All right.
The interim order, my lord.
All right. Rejoinder will be filed for the next date. Interim order to continue.
I'm filing the copy of the counter in
23rd November.
My lords.
Supplementary list item 22.
My lord, item 20, Mr. Professor Behra is appearing with me. Let's make it.
All right.
Item 22.
May it please, my lords. I'm appearing in person.
Yes, Mr. Paddy. This came up yesterday. None of you was there.
Sorry,
I had asked Union of India to file a specific affidavit. This item 22. This is that
Yes,
Duchenne muscular.
yes, my lord. We have received an instruction that now they are preparing to give the proper assistance and given. We will file a details affidavit. Let's see.
When will you file it?
Within 2 weeks, my lord.
Mr. Paddy.
Lordship, they have taken sufficient time in the matter.
I know. States as that. No, as a last opportunity.
EMD patient, let's see, that case, yes. Yes.
Mr. A last opportunity is granted to the Union of India to file its counter affidavit within 2 weeks. List on 15 September.
Obliged.
Supplementary list for hearing item number 23.
May I please, my lords?
Yes.
As in this case, your lordship by order dated 26/2022 have formulated 3 questions, my lords.
Yes.
My lord, your lordship have formulated 3 questions on the last occasion. And my lords, question number A and B, this honorable court has answered these questions earlier, and I will be taking your lordship's attention to that. Only question number C need to be, my lords, examined and answered.
Right.
Question number A, my lords. Let me read whether in the fact and circumstances case, refinery unit set up by the petitioner by way of expansion after 1/12/89 is eligible for sales tax incentive under the provisions of Central Sales Tax Act in respect of interstate sales read with entry 30FFF2 of the tax bill schedule under the Orissa Sales Tax Act. Because what has happened in this case, all the fora below, assessing officer, first appellate tribunal, they have extended the benefit up to up to 98 minutes. And this honorable court, I have last occasion filed one compilation of documents along with judgments of your lordship. My lords may kindly see this petitioner's case, my lords, dealt in STRV number 470 of 2008. That is the first, STRV 470 of 2008. This pertains to 99/2000. Under the OST, and your lordship in this case is concerned 99/2000 CS2. And this honorable court has held that this benefit of exemption provided under 30FFF2 has been withdrawn by government notification dated 16/8/90 from 1/8/99. So therefore, your lordship said that the petitioner is entitled to avail exemption up to 31/7/99. That means only for 4 months. So far as 99,200 concerned, for the whole year I will not get. I will only get minutes up to 31,799. That is what your lordship have said. That will follow for this case as well.
All right.
This is 1 minute. So far as second question is concerned, but your lordship have seen the order. Let me not place this 470. Your lordship have said so. Now, my lords, second question is whether in the facts and circular case, furnishing declaration from F in respect of claim of stock transfer under Section 6 of the CST Act is mandatory, and whether it is proper on the part of the law and tribunal to not to make any deliberation on the said issue is pleaded before it. But so one thing, this declaration Form F, filing of Form F has become mandatory with in 2002 after Parliament amended the provisions. Prior to that, before 2002, assessee can establish the factum of branch transfer by any other mode, by adducing evidence. Form F was said to be one of the modes. So, and now after 2002, Form F has become mandatory. If one fails to furnish Form F, the transaction is treated to be not by reason of branch transfer, but by reason of sale. That is the presumption also, deemed presumption provided in the statute. Now, on this, your lordship have considered the very next order your lordship may kindly see. That was
471.
471. Here your lordship says, because I have pleaded, I have therefore filed grounds of appeal along with this compilation, that your lordship will find serial number 6, Form XB filed for Orissa Session along with grounds of appeal at page 28 to 31. 31, page 31. I have filed with us the copy of the memorandum of appeal and the grounds of appeal. Ground number, my lords, ground number, your lordship may kindly see. Ground number 5. For that, at page 31, running page 31, for that disallowance of consignment sale is illegal and bad in law. This consignment sale is the stock transfer loss. So this has not been answered by the Honorable Tribunal. And your lordship in 471, STRB said that because this has not been considered pleaded, so matter to set aside and examined by the Lord's authority once again, by the tribunal. So that is how your lordship, and your lordship also referred to Miller's judgment of our High Court in Orissa, Small Scale Justice Corporation, Hanuman Store, where this Honorable Court has said, the one what I submitted for lordship, that F form is not mandatory prior to 2002.
So after remand to the tribunal, still pending the tribunal?
The other case, Lord.
No, this, what you just now read. Ground 5, you said in 471, they have remanded it to the tribunal.
They remand that outcome, I'm not aware of, Lords. But this Honorable Court set aside saying that they will examine, and if you adduce evidence, that will be considered. But so that is how question number 2, Lords, your lordship have answered. So question number 3, Lords, this requires determination. What is question number 3, my lords? But whether in the facts and circumstances case, the levy of surcharge purportedly under Section 5A of OST Act is lawful and valid in respect of transactions of the CST Act. That's 5A is a provision that also your lordship have answered in some form or other. I will tell you, lordship. That's 5A is a provision under the Orissa Sales Tax Act, which says that if one is liable to pay sales tax, in addition, that provision is no more there, but still by then it was there. In addition to tax payable, he is liable to pay surcharge, 10% of the tax payable, Milords. There are some exceptions; those are not relevant in the context. Now the question is, Milords, that was a levy on and total complete mechanism available: assessment, reassessment, refund. 5A is an autonomous provision to take care of all eventualities. How to make assessment, that's how to determine, everything is there. But here, this assessment is not on the OST Act. This is under the CST Act. The assessing officer has dragged the provision to such an extent that because I failed to furnish declaration of F, Milords, he treated the branch transfer as if these are all interstate sales, and assuming that these are all interstate sales, which provision doesn't say interstate, provision says that will be treated to be sales, Milords. Now the second question is whether it is interstate or interstate, that is another question. Assuming that they are interstate sales, and assuming that he has not...
So it's anyway consequential in question number 2.
Consequential.
So it has to await decision question number 2 then. It's premature. Once we send it back, there's no need to answer this.
That can be, yes.
Yes. The following 3 questions have been referred, framed for consideration by this court in the present revision petition by the SSC, arising from an order dated 25th April 2008 passed by the Orissa Sales Tax Tribunal. In essay number
Milord, your lordship may kindly mention essay number 29C of 2012. That is CS2.
or 29C of 2001-2 for the period 1999-2000. Then reproduce the questions from the order dated 20th June 2022. Paragraph. As far as question A is concerned, it stands answered by the order dated 5th June 2016 of this court in STREV 470 of 2008 involving the very same SSC, where a similar question arose under the Orissa Sales Tax Act 1947 (OST Act). In that order, it was held that the benefit under the IPR 1999 would be available to the petitioner till 31st July 1999. Full stop. Accordingly, question A is answered by holding that the benefit under the CST Act to the petitioner would correspondingly be available under the IPR 1999 till 31st July 1999. Paragraph. As far as question B is concerned, the court's attention is drawn to an order dated 21st June 2016 passed by this court in STREV 471 of 2008 filed by this very petitioner. Full stop. That revision petition arose from an order passed by the Orissa Sales Tax Tribunal in an appeal for the period 1999-2000, where one of the grounds concerned disallowance of single quotes consignment sales, unquote. This court, by the said order, remanded the said issue to the tribunal since the tribunal had failed to address that ground. Full stop. Mr. Sahul and senior counsel for the petitioner states that the outcome of the remand to the tribunal in this by the said order is not known. Full stop. As far as the present case is concerned, the court considers it appropriate to remand this issue to the tribunal for a fresh decision in accordance with law, in light of the above order of this court, dated 21st June 2016 in STREV 471 of 2008. Paragraph. As far as question C is concerned, the question arose only as a result of the tribunal holding the branch transfers to be sales. Full stop. Since that question has been remanded by this court to the tribunal for a fresh decision, this question has to await the decision of the tribunal, fresh decision of the tribunal. Full stop. Consequently, the question is not answered at this point in time, except holding that the decision of the tribunal in this regard is hereby set aside, and it will await the fresh decision on this regard by the tribunal, depending on the answer to question B.
Okay. Okay.
The revision petition is disposed of in the above terms.